The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice.
For this morning? Okay, and the parties are prepared to proceed? Okay. All right, then we just need Ms. Johnson. Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable. Let me know when you're ready to proceed. Yes, sir. All right, and please state your full legal name and spell your full legal name.
Kelly Johnson, Kelly Johnson.
Thank you. And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? All right, thank you. Please proceed. Yes, sir. Yes, sir.
Ms. Johnson, would you state your name for the record, please?
I did, Kelly Johnson.
Okay. And do you remember being judicially appointed on this case involving Ms. Shaver? Okay. If I can approach Judge and show her
Yes, sir.
Defense Exhibit A for identification purposes, which is the order. You look at Defense Exhibit A for identification purposes. Is that the order you're looking at wherein Judge Singletary appointed you to this case?
Yes, sir.
And in the respect of order, what was your understanding your obligation was?
I was appointed to represent the child as an attorney ad litem.
Okay. And the child's name?
Laurie Shaver.
Okay. And having been appointed on behalf of the minor child, did you meet the minor child?
Yes, I have.
Did you discuss with her the facts or knowledge of the case with her?
as with any client, I discuss the facts of the case, the applicable laws, and possible ramifications of taking any position.
So, did you discuss with Isabel, did she express to you in any form or manner that she had any interest to testify in this cause?
She expressed a preference to me in a developmentally appropriate manner.
I'm sorry, speak up.
She expressed a preference to me in a developmentally appropriate manner.
Ms. Johnson, can you pull the microphone towards you a bit? It's adjustable, and speak into it to the best of your ability. Thank you.
Did she express to you, I'm not sure if I understood your answer, Ms. Johnson, did she express to you an interest in testifying in this cause?
As I stated, she expressed a preference to me in a developmentally appropriate manner.
Okay.
I can't discuss
The context.
anything that the child and I discuss, as it's bound by attorney-client privilege.
Right. Did you discuss when you were meeting with her, if she were to testify, the rights, constitutional rights, that she would be waiving by testifying?
Yes.
Did you express to her any legal penalty which she could face if she were to testify and the state took action against her?
I advised her as I would any client.
Did you detect any infirmity with regards to Isabel if she were to testify, that she would have a problem testifying truthfully?
That's not within the scope of my representation of the child.
So did you feel that the child was being honest with you?
Again, that's not for me to determine. The scope of my representation as an attorney ad litem is to advocate for the child's, what I feel is her position, if she's able to articulate that, and to advise and provide the any guidance I can in advocating for their position.
Did you detect any infirmities with the child communicating?
She didn't have any problems communicating with me.
Did you detect any issues that would raise concern for you as a guardian?
I'm not a guardian ad litem.
Well, an attorney ad litem in this cause, correct?
I'm an attorney ad litem. It's a distinct and different role than a guardian ad litem.
Did you detect any fabrication?
Again, that would,
Without going into any discussions that she had with you, did you detect any fabrication?
again, I don't believe that I would be able to express an opinion about that. That's outside the scope of my representation as an attorney ad litem.
Based on what your client had expressed to you, did you at any time meet with the office of the state attorney?
I participated in the proceedings consistently with my representation of the child
Was that at the behest or request of your client?
in advocating for my client's position.
Okay. After that meeting, did the office of the state attorney contact you at any time to converse with you or your client after that conversation?
The child was subpoenaed to be deposed in the case.
No. Before the child was deposed and yet after that meeting you had with the state, did the state show any interest in meeting with your client or law enforcement to investigate anything that you had revealed to the state?
I don't believe that there was any participation in the proceedings until the child was subpoenaed to provide a deposition.
And did you appear at the deposition with your client?
Yes, I did.
And was the state aware that you were representing her?
I assume that they were
Okay.
aware.
Tess, I'm sorry. You mark this as C, I guess. which is what's marked as Defense Exhibit C for identification purposes. It's on the heading, it says Supplemental Discovery Number 31, issued by the State Attorney's Office. Does this document carry your name?
Yes, it does.
Thus, you would agree the state was aware that you were representing Isabel Shaver. We move that into evidence. Judge, we move C into evidence at this time.
For purposes of the hearing, that's fine.
All right, without objection, Defendant's Exhibit C will be moved into evidence as defense number 1.
And A as well as defense 2.
Any objection?
No, just for the purposes of this hearing, no objection.
Yes, sir. All right, Defense Exhibit A, without objection, will be moved into evidence as defense number 2. For the purposes of the proffer. And that's everyone's understanding, correct?
Yes, sir.
Okay, all right.
Yes, sir. Ms. Johnson, the other day, the issue arose, the state having been supplied a copy of the order by the court appointing you as the guardian, that you were not on a official witness list of the defense. You've met with the state, correct?
What do you mean?
Met
I
with
mean,
the state at a deposition.
yes,
You traveled to the state and met with them, correct? To discuss your client's case.
yes,
They were aware you were involved in the case, correct?
I assume that they are aware.
Yeah. They directed a pleading with your name, service on it.
They served me with the subpoena, yes.
Pardon me?
They served me with the subpoena.
They put a witness with your name on it, okay? Care of you,
Yes.
okay? If called to the stand in this cause,
Thank you.
the defense would intend to limit your involvement just to the facts. Did you meet with your client? Did you advise her of her rights? Did you see any defect or deformity or issue that would preclude her from testifying truthfully? Is there any rule or anything that would prohibit you from asserting those facts before this court?
No.
Judge, we had listed formally, and I've supplied it to the state, what's now marked as Defense Exhibit B, which is Kelly Johnson's name on a formal witness list to alleviate any question of any intent to call. She's expressed what her limited purpose would be. We moved that into evidence at this stage. A copy has been sent by e-portal to the state attorney's office and hand-delivered here in open court. We don't believe that any prejudice would inure to the state if Ms. Johnson were to testify on these limited facts and would be for the purpose of conforming and confirming the competency of her client to testify in this cause.
Has that document been marked as an exhibit?
Yes, sir. And it's been moved in, it's been sent through the e-portal.
Any objection to Exhibit B being entered into evidence for the purposes of the proffer? Okay, without objection, Defense Exhibit B will be entered into evidence as defenses number 3. All right, please proceed.
Good morning, Ms. Johnson.
Morning.
So the majority of things that Mr. Wiggs was asking you about are conversations that you had with Isabel Shaver. Is that fair?
That's fair.
Okay. And those conversations that you had with Isabel Shaver would be out-of-court statements,
Correct.
and the purpose of putting those out-of-court statements in about your conversation would be to prove exactly what happened in that conversation.
Well, it would be eliciting statements made by my client and something that I could not testify to based on the privilege and confidentiality of our communications.
So he's asking you about hearsay out-of-court statements.
Yes.
Okay. And so you can't talk about out-of-court hearsay statements Can't talk about opinions that you've already said, correct?
I mean, I guess I could testify to that unless there was an appropriate objection made and the court ruled that that I could not make those statements. But the other prong of that is my role in representing the child in this case as an advocate and as an attorney. I'm bound by the professional conduct rule.
Absolutely. And after, and actually Mr. Wiggs actually sought you out and asked you to participate in this case, correct?
There was a conversation about whether I would be willing to accept the appointment.
Then he requested Judge Singletary appoint you.
I believe there was a motion filed, yes.
This was not a scenario where Mr. Wiggs asked the court to appoint an attorney and Judge Singletary just said, you know what, I think Kelly Johnson would be perfect for this, correct?
I don't know that.
Have you seen the motion that Mr. Wiggs filed where he asked for you to be appointed?
I don't recall if I've seen the motion.
After you were appointed, you would agree that there was multiple conversations between yourself and me in the hallways about any time you want to bring your client to talk to me, I'm available. Do you remember those?
Yes, we did have conversations.
But you, serving as a good defense attorney, would not allow her to speak to me until I provided a subpoena, which then gave her immunity. Is that fair?
That's fair.
Okay. So it's not that I never contacted you. You, as a competent defense attorney, wanted to protect your client and wanted to wait for that subpoena to be issued.
That, and I also needed to make sure that my client was well informed on and advised in their participation in this proceeding.
Nothing further, Judge.
All right, Mr. Wiggs.
Please support. Ms. Johnson, with regard, you practice criminal law, correct?
Correct.
Now, the state just went through a litany question and stated, in essence, anything you would say would be hearsay of what your client said, correct?
The rules of evidence say, if I testify to an out-of-court statement, that's hearsay unless there's an exception to that.
Correct. As a criminal attorney, you appear in court frequently, correct?
Yes.
And at any sentencing, any and all sentencing, in fact, every sentencing, every attorney has to go through a litany with the court about the rights that they've advised their client on, correct?
Correct.
The right to remain silent, correct?
Correct.
Maximum penalties, correct? Their presumed competence and desire to enter a plea,
Yes.
the waiver of appeal, correct? There's 6 different things that go into that. Waiver of discovery and the ability to proceed at that time. You also make a representation, do you not, that you believe the client, having discussed these facts, is competent to enter the plea, correct?
Yes.
And none of those go into a discussion that you have with the client about what they said, what they did. It's just a statement of their desire to move forward, correct?
Correct.
Okay. Now, if you were called to the stand in this cause, do you have the ability to represent those rights that you'd advise the client of and the preference of the client to move forward without discussing the exact conversation, like any other criminal case?
Yes.
Thank you, Judge.
Nothing further.
All right, and Ms. Johnson, you're excused from further testimony, and Ms. Johnson is to remain on standby, is that correct?
Yes, Judge.
All right.
Assuming you're saying that any of that is actually admissible.
I haven't ruled yet,
Right.
but knowing that I haven't ruled yet, would you like Ms. Johnson to remain on standby?
Yes, Judge.
Okay, please remain on standby. You may step down from the witness stand. Thank you. Okay, proceed with argument.
Yes. Judge, Ms. Johnson was appointed by the court recognizing there's a conflict. I can't represent her. I can't talk to her. Ms. Johnson can verify I haven't talked to her. There's been no influence. The child is aware of these constitutional rights. It's a summary proceeding, not revealing any conversations that Ms. Johnson has had with the client, just that she believes the client's competent to move forward, and that's the desire of the client. It's a perfunctory function. The state has been aware from the moment Ms. Johnson was listed in this cause as to her interest in the matter. The state's not prejudiced in any respect. If we were to call up a Richardson hearing and direct this towards a Richardson hearing, the state could point to zero facts how they've incurred any injury, damage, or prejudice in this cause by calling Ms. Johnson at this stage. So we'd ask that, she's been listed formally. The state's known who she is. She's been to their office. They've spoken to her in the hall. There's no reason to exclude her, just for purposes of clarity and allowing the matter to proceed and finish the matter up in an orderly process.
Tell me exactly what you intend to elicit from Ms. Johnson.
Correct. Okay.
Thank you.
Yes, Judge. Anybody that testifies, the court has to be satisfied, as in a criminal case, that they understand their rights, they intend to testify, they understand their obligation to testify truthfully, and intend to do so. That's really a pretty simple process. Because Ms. Johnson was appointed as the guardian in the case, we want to elicit that there's been no tampering. We haven't tried to communicate with the child, and she's been the one in charge and directing all conversations. So she would just provide that function of saying, I've spoken with the child, she understands her rights, she understands her responsibilities. It's her desire to move forward, understanding the potential charges that could be levied against her, and that she believes through her conversations that the child's competent at that stage. That's it. It's pretty perfunctory, to tell you the truth. If you don't have Ms. Johnson, the child can still testify. It just draws the court to have to make every little decision in that case. The state has taken the position, well, she's older now, you don't need Ms. Johnson. That's what they were advising us the other day. I think it's advisable to have Ms. Johnson just to clear up any ambiguity or issues regarding any competency with regards to the minor. If the court is not satisfied with that, we'd ask that the court have a Richardson hearing and at least have the state provide proof that they've been in some manner prejudiced by this. So we'd rest on those issues and that argument at this stage. Thank you, Judge.
All right, thank you, sir. State?
Your Honor, my motion made it very clear that I'm not asking Ms. Johnson to be excluded because of a clear discovery violation by Mr. Witts. I put that information into my motion because Mr. Wiggs made an affirmative representation to this court that he had in fact listed Kelly Johnson, and that is just not true. I'm not asking her to be excluded because she was disclosed late. So the need for a Richardson hearing and discussions of any sort of prejudice because of their late disclosure is not necessary. The reason why I am asking her to be excluded is because she can offer no testimony in this case. Everything that has been asked of her has been about out-of-court statements, that would be hearsay, and he tried to elicit opinions as to this witness's veracity, which is inappropriate. And the decision as to whether or not any witness is competent is for the court. And the common law rule actually dealt with the fact that children under the age of 14 just are not competent. That has been abrogated by years of case law, and that's where the questions regarding do you understand the difference between truth and lie? Do you understand the difference between fantasy and reality? Do you understand the concepts of making a promise, and will you be truthful in order to determine whether a witness is competent? This witness is now 16 years of age. I don't even believe that inquiry would be necessary due to her age at this point, and she could just take a standard oath. But if the court, in abundance of caution, wanted to make those inquiries, that would be fine. She's given a child advocacy center interview, which was recorded, where she has fully established her competence and the fact that she understands the difference between truth and lies. She understands the difference between fantasy and reality. She did it again during the deposition. There's no reason to question competence, and there's no reason to have Ms. Johnson come in to give opinion testimony about her competence. And once you go through those issues, which is what Mr. Wiggs has proffered the testimony to be, we are left with nothing. And so, since we're left with nothing, that's why this witness should be excluded.
Judge, I would disagree with the state. The state's saying this is opinion testimony. At every sentencing conducted in this court or any court, the attorney has to render an opinion to the court. I believe my client's competent to enter this plea. So to say Kelly Johnson has no bearing or issue in this case is a misrepresentation to the court. But the state was advised of her, and it was court appointed. When I advised the court the other day, she had been listed. She was court appointed, of which the state had full knowledge. The reason we sought Ms. Johnson out was to create a barrier. In light of the charges that the child could be facing, it's a safeguard for the court, irregardless of age, okay? And we don't want it to appear that this child has just come in here and somebody's just thrown the child under the bus. That she does have a representative that's gone over certain things with them. But certain opinions, as the state's offered a lot of opinion testimony through the witnesses in this case, it is appropriate. It's appropriate in any sentencing, and opinion is proper at certain times.
And Ms. Johnson was appointed in March 15th, 2022, correct?
Pardon me.
So it's been a 2.5-year process.
Correct.
It wasn't as if Ms. Johnson was appointed a week ago.
Correct.
No, and like I said, I'm not claiming.
Well, it's not about the Richardson hearing. It's about getting to know her client and then knowing her client and being the attorney ad litem for the past 2.5 years. So in terms of Mr. Wiggs' request, I'll grant the request, and for the limited purposes requested by Mr. Wiggs, Attorney Johnson's testimony will be permitted.
Your Honor, just, but the questions regarding his inquiries into the veracity of this witness, which Ms. Johnson refused to answer, I would ask that those questions be excluded and not be asked.
And that's to make the objection at the appropriate time, not try to get every little ruling and pre-trial like this, Judge.
I believe Attorney Camuccio doesn't want the bell to be rung. Is that correct? Because he can't unring the bell.
And if I'm aware that there is something that would be improper to be presented to the jury, it's my job before it happens to bring it to the court's attention, which is what I am doing.
So please do not inquire as to veracity or perceived veracity by Attorney Johnson.
Very well, that's fine.
All right. Is there anything further?
Yes. It has come to my attention that yesterday, after the court proceedings, that there was a time frame out in front of the courthouse where Mr. Wiggs was speaking with the media on camera with Ms. Shaver present. There was a juror that was sitting on the courthouse steps in proximity to that. I'm not saying Mr. Wiggs, I don't even know if he knew that she was there, but the issue that there was a witness present while Mr. Wiggs was obviously discussing the case, a juror there while Mr. Wiggs was discussing the case with the media, I believe we need to address. The particular juror is Mercy Langley. It was juror number 10. She was the juror that Mr. Wiggs had concerns about on the first day about having her head down and potentially not paying attention. She's also the same juror that during one of the bench conferences seemed to be carrying on some sort of conversation. I just believe we need to have the court bring her in, make juries about that issue, and then
About the issue with Mr. Wiggs giving the interview, or about the conversation?
probably need to take care of both. At this point, we have at least two red flags with this particular juror, and I think we should explore that potential third one. Just have the court inquire about those two issues, and then let her go back in the jury room, and then we can figure out if we just need to go to one of the alternates, or if Mr. Wiggs, based on the prior concerns of that juror, just wants to have her removed, still sit on this jury through the pendency of the case, but replace her with an alternate. At this point, we can do that as well.
All right, I will inquire of the juror, and we'll call the juror out individually. Are the parties ready to go?
Yes, sir.
All right. Then please call out Miss Langley, if you would. Thank you. Swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God. All right. And you're not in any sort of trouble. We just have a few questions for you. And were you sitting on the courthouse steps yesterday?
Yes.
Okay. And when was that?
I sit out there every day at 5 o'clock because that's when my grandfather comes to pick me up.
Okay. And did you see Attorney Wiggs seated at the table next to his client outside?
Yes, I did, and I tried not to, I didn't look at them. I tried to pretend that I didn't know them.
And that's fine. Did you hear him say anything?
No.
Okay. Did you see Attorney Wiggs giving an interview?
Yes.
Okay. Did you hear any of it?
No.
Okay. And also yesterday in the jury box, there was a conversation. Were you speaking with the other jurors?
Yes.
Okay. And about what?
I don't remember.
Okay. Don't recall. Were you speaking to just one other juror or multiple jurors?
I think it was about one of the photographs because it made me uncomfortable.
Okay.
That was it.
All right. Do you recall which photograph?
It was one of the sexual ones that was being shown on TV.
Okay. All right. State, any questions?
Yes, sir.
Okay. Mr. Wiggs? All right. All right. At this point, Ms. Langley, you'll return with the other jurors, and we will call you in shortly. Thank you. All right. Based on that, what are the parties' preferences?
I asked the state, they raised it. They've heard the testimony. It's fine.
Okay. The juror does not need to be excluded. Okay. Mr. Wiggs? Okay. So based on the stipulation of the parties, Ms. Langley will remain on the jury. All right. Thank you.
When the jury does come in and you go through the normal, media.
Yes, sir.
Can you also give them a reminder, though, that they're not to start deliberations until everything is done, not to talk about any of the particular evidence? I'm not saying that.
And I believe I always have.
Okay.
Yes, sir. Not to speak with each other or anyone else.
Perfect.
So, all right. Anything further?
No.
Yes, sir.
All right. Please call in the jurors. Thank you. All right, please be seated. I see that all of the members of the jury have returned. I have some preliminary questions for the jurors. Has anyone spoken to anyone about the case? Any of the jurors, have you spoken to anyone about the case? Have you spoken to each other about the case? And everyone has answered no. And has anyone done any research regarding the case? Has anyone viewed any articles or newscasts on the media, read about it? All right, and everyone has answered no so far. Has anyone seen the attorneys or interacted with them since yesterday? All right, and everyone has answered no. And again, please do not discuss the case with each other or begin any sort of deliberating or deliberations prior to the conclusion of the case. So have you all followed those instructions? Okay. All right, any inquiries from counsel? Okay. All right, then please proceed.
State calls Jeremy Townsend.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable. Let me know when you're ready to proceed. Please state and spell your full legal name.
Jeremy Townsend, JeremyTownsend.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Okay. All right, thank you. Please proceed.
Please introduce yourself to the jury.
Jeremy Townsend.
Now, Mr. Townsend, a couple of questions up front. Do you currently have an attorney?
Yes.
And when did you retain?
January 2022.
Prior to retaining an attorney, had you spoken with law enforcement
Yes.
about the matters of this case?
Yes.
And had you spoken with them multiple times prior to retaining an attorney?
Yes.
And why did you retain an attorney in this matter?
When my name came out as part of this case, my wife and I felt that we would retain an attorney to help us through the process, help us understand the legal side of this.
But you were willing to talk to law enforcement on multiple occasions before ever doing so?
Yes.
And you responded to all subpoenas and requests to speak with officers?
Yes.
Have you ever been in the military?
Yes.
And first of all, what branch?
United States Army.
And when did you serve?
Served from 1998 to 2003.
And why did you leave the military?
I was shot 3 times in Afghanistan and was almost killed. Was medical retired out.
And the jury has seen photographs that have been shared between yourself and Ms. Shaver already, some of them full body shots. Where were you shot?
Through both my legs, and one right through my side.
Now, do you know Laurie Shaver?
I do.
How did you meet her?
I met her at one of the public parks.
And about when did you first meet her?
September 2015.
And what were you doing at the park?
I had my son there.
Are you married?
Yes,
How long have you been married?
16 years.
How old was your child at that time?
About 5.
And what was the kind of home-work relationship? Wife work, did you work during this time frame? What was going on there?
My wife works. I'm retired out of the military.
And when you met Miss Shaver at the park, did she have any of her children there?
She had her son.
And did you all begin some sort of, did you chat with her? Did you start some sort of relationship? What kind of developed from there?
She approached me and asked if it was okay if her son played with my son.
Do you see her in the courtroom here today?
I do.
Can you point her out and identify her by something that she's wearing?
She's wearing a black shirt with white
Which seat is she sitting in?
next to Mr. Wiggs.
And when you would communicate with her, would she call you Jeremy or would she call you something else?
Jay.
After that first time you met her at the park, did you see her again?
Yes.
And was that also at the park or was that at another location?
It was at the park.
At some point, did you all exchange phone numbers?
Yes.
And when approximately was that?
About the 3rd time I met her.
Did you all exchange text messages and phone calls?
Text messages.
After starting to text back and forth, at some point did a physical relationship begin?
Yes.
And
Yes.
about when did that happen?
First week of December 2015.
How often would you see her?
1 to 3 times a week.
And when would these visits occur?
It would occur during her lunch break,
Did
which
she
would,
work at home?
yes,
And when you would go during the lunch break, were her kids there?
no,
Where was your son when you would go over to the house?
in school.
Did you ever go over to her residence and spend the night during this time frame?
No,
During any point in your relationship, did you spend the night over at her house?
no,
And we've discussed the fact that you were married at that time. Is it fair to say your wife did not know about these occurrences?
Objection, Judge. It's opinion, testimony, speculating about his wife's understanding and factual state of mind.
I'll rephrase, Judge.
It's all right. Did you have knowledge of it? Did you know whether your wife knew or not?
my wife did not know.
You definitely didn't tell her.
No,
Objection, meeting.
All right, overruled. Please move on.
Had you stayed out overnight and spent time away when your wife was around, that would raise suspicions. Is that fair?
correct.
It's leading, Judge.
Sustained.
Were you trying to avoid raising your wife's suspicions?
Yes,
Did she tell you about her marital status?
yes,
And what did she tell you?
that she was going through a divorce.
Did she tell you her husband's name?
Michael Shaver.
Did she tell you where he was?
She said that he had left with a friend in a vehicle.
Okay. And when did that happen in relation to when you started this physical relationship with her?
When she told me that Michael had moved out, that was November 2015.
And so the time frame that you started going to the house was after that.
It was the first week of December.
During the course of the affair, would you exchange text messages, phone calls, and photographs?
Yes.
And during this time frame, what was the status of your marriage?
My wife and I were not in a good place. We were kind of going back and forth if we were going to stay or get a divorce.
Was there ever a time that Laurie Shaver expressed to you that she wanted you to leave your wife to be with her?
Yes.
And was that what you wanted?
No.
Did there ever come a time in February of 2016 where Laurie Shaver was upset with you about your status with your wife and your refusal to leave the marriage?
Yes.
Excerpt from the Facebook records already in evidence from Michael Shaver. Do you recognize those text messages?
Yes.
And first of all, how do you recognize those text messages?
Laurie sent those to me.
And does it include communications with you and her back and forth?
Yes.
Your Honor, at this time, the state will move states QQ into evidence. The states
45, I believe.
Same objection, Jack.
Same okay, objection is overruled. States QQ will be entered in evidence of states number 45.
go ahead and publish. Go ahead and refer to the exhibit that you have there. First of all, there's a couple phone numbers on here. On that first page where it says receiver 352-431-01419, whose number was that?
I don't recognize it.
Okay. Well, what about 352-613-4100?
That's mine.
Okay. And these are all text messages. You recognize the messages from the content as being between you and Ms. Shaver?
Yes.
Okay. And the first message that I want to draw your attention to is on the first page, February 23rd, 2016. Was that a message from Laurie Shaver to you?
Yes.
And up top there in the white, this is one at 10:17 p.m. What was the content of her message to you?
Why did you lie to me?
Okay.
That one?
Yes.
Yes.
Go ahead and read the whole thing.
Why did you lie to me about Saturday night?
And then moving on to the next page, 10:03:48 p.m., still February 23rd, 2016. What was the content of the message you received from Ms. Shaver there?
No wonder why you shaved your beard.
Okay. And what about the first message, the 10:03:48 on the bottom?
The neighbors.
Yeah, that statement.
Yeah, neighbors my
You can go ahead and say it.
neighbors my ass.
And when she's talking about neighbors my ass and no wonder why you shaved your beard, what is she referring to there?
I had shaved my beard completely off. I had a little smaller beard, kind of like yours, and shaved it all off. And she was saying that her neighbors could vouch for the affair.
Okay. Going on to the next page, at 10:08:45 p.m. On the bottom in the gray, what is the message that she sends to you there?
Nice wedding ring. Thought you didn't wear that anymore.
What is she referring to there?
I had my wedding ring I had put back on. Had a picture with my wife. It was posted on Facebook.
And did this cause arguments between you and Laurie Shaver?
Yes.
And that was in late February of 2016.
Yes.
Sometime after that, did you learn that your wife found out about the affair?
Yes.
And how did that come about?
My wife contacted me April 12th, 2016. She had received flowers.
And then did that expose the relationship between yourself and Laurie Shaver to her?
Not at first, because she asked me who Mike was.
Okay.
And I did not know who a Mike was. Once she checked her Facebook and seen the messages from Mike, it started to come out.
And that was when?
April 2016.
At any point when you were over at the Shaver residence, was Michael Shaver there?
No.
At any point did you arrive on a scene where Michael Shaver had been shot?
I say what?
At any point did you arrive at the Shaver residence or any other place where Michael Shaver had been shot?
No.
At any point were you involved with any sort of altercation with Michael Shaver?
No.
At any point did you shoot or injure Michael Shaver?
No.
At any point were you involved with disposing of the body of Michael Shaver?
No.
And after the affair was exposed, what happened with your relationship with Laurie?
I cut it off.
Nothing further, Judge.
Thank you. Mr. Wiggs?
Yes, may it please support.
Yes, sir.
Let's go back to the original part of your testimony, Mr. Townsend. You represented, you had tension with the wife, and you broke up with
I
her.
didn't break up.
Well, you weren't seeing her, right? You were just sleeping with her?
With who?
Your wife.
Say it again?
You were still living in your marital residence, correct?
Yes.
And you stated earlier y'all were having problems, the two of you, correct?
Yes.
So you guys are having problems, and you're cheating on your wife, correct?
Yes.
And at the same time, you said, but I don't want to end the relationship, correct?
Correct.
Okay. And so you stated that you go over to Laurie's about 1 to 3 times a week, correct?
Correct.
And what time would that be?
11 to 12.
Okay. Never any earlier, correct?
Correct.
In fact, you went over there more than 1 or 3 times a week, correct?
No.
In fact, you got Laurie pregnant, did you not?
No.
You stated that you never spent the night there, correct?
Correct.
So, if anybody were to testify they saw you spending the night there, you know where that may be coming from? Somebody look like you know?
I would not know who would say I'd stayed the night there because I never
Okay.
stayed the night there.
You ever represent to Laurie you'd protect her from Michael? That you were a military guy and had special training?
Not in that sense, no.
That you were in black ops?
No.
Okay. Your position, we've heard on your direct examination that you met her in September of 2015, correct?
Correct.
Okay. Have you ever made a statement inconsistent with that?
Not that I'm aware.
Not that you're aware of, okay? I'm going to show you your deposition, page 5, beginning on line 11 through 12. I want you to read that to yourself.
What line?
11 through 12. Does that refresh your recollection?
Hang on. It just goes on to say how I met her.
Now, I asked you, have you made a statement inconsistent with that September of 2015 date? In fact, on line 11, you state, I met her in the park. I don't know when. I mean, it was a long time ago. Correct? That was your statement earlier in time, correct?
Correct.
Now, we're at trial years later, and you've got it pinpointed to a particular month and year, correct?
I don't have to pinpoint it.
You did. On your direct examination, you said September of 2015, correct?
As I went back,
Sir, did you not say on direct examination September 2015?
correct.
Did you not? Earlier, you're telling me, I don't remember when. Correct?
Correct.
Okay. In fact, you went to the house, spent Christmas with the Shavers, did you not?
No.
If anybody were to take the stand and say otherwise, do you have any idea why they may be mistaken about that fact?
I was there before Christmas, but I did not go there and spend Christmas with the Shavers.
Well, how long were you before Christmas?
I was there the first 2 weeks. Kids got out of school for Christmas break. And I was home with my family.
Okay. So how long did you spend during that time period around Christmas with the Shavers?
The first 2 weeks of December 2015.
Ever go shopping with the Shavers?
No.
Since Laurie, since you went back to your wife, excuse me,
I didn't leave my wife.
well, you were over there with Miss Shaver having an affair, were you not?
Correct.
I wouldn't say that's gainfully spending time with your wife, is it? Sir?
No.
And when you went back to your wife, is it not a fact you continued to follow Laurie?
No.
Never met her in a store?
No.
Never pulled up to her next to the light?
No.
Never drove by her house?
No.
Okay. So you testified you were in the military, I think, between 1999 through 2003, correct?
1998.
98, okay. And 2003, correct?
Correct.
And you suffered this injury,
Mhm.
correct? Have you worked at all since then? Nursery?
I did work.
Okay. And you're receiving government aid and assistance, correct?
Yes.
Did you tell the government about that? You're working?
Objection, Your
I-
Honor.
Relevance?
Overruled. Answer the question, please.
Did you tell the government about that?
I didn't have a retirement at that time when I first got out.
Okay. So when you got retirement later, then you became more ill or something?
Yes.
Okay. Are you working today?
No.
I'd asked you earlier if you were in special ops or a sniper, I believe, correct?
Correct.
Okay. Do you ever represent anybody that you were?
Not that I'm aware.
Okay. Let me show you your deposition. Page 8. Line 25. I want you to read that to yourself. My question again, did you ever make a representation to anybody that you were in special ops? Reading your deposition, does that refresh you?
It states that I didn't
Sir,
represent
can I ask you
myself.
that question? Does that refresh your recollection?
Objection, Your Honor. He was trying to answer the question.
No, I asked him if that refreshed his
Please
recollection.
re-ask the question and please answer directly.
You read your answer, correct?
Correct. It
My
says I
question to
don't.
you is just this. Did that refresh your recollection whether or not you ever made that representation?
And I stated it says I didn't.
You represented, no, I said, no, question, no, I said to anybody, that I don't know. That I don't know, correct?
Can I
So
just
were you going around telling people, Mr. Townsend, you'd been special ops?
I was not saying I was special ops.
Did you ever tell Laurie again that you'd protect her from Michael?
No.
You had discussed with Laurie about getting a divorce, correct?
I said me and my wife were in a bad spot and we had talked about a divorce.
Now, Laurie wouldn't be satisfied with that explanation, would she? She'd want a little more from you than that, correct?
Correct.
So you had to broach this topic, make some representation that you guys were going to be an item in some fashion, correct?
No.
Okay. Laurie was content with you saying, well, I'm going to stay with the wife, I'm just over here having some fun?
The agreement in the beginning was
Sir, is that what the relationship was?
Your Honor, please don't let him answer his question.
No, not the question, what I'm asking about.
Can we approach?
Come on up for a sidebar, please. Thank you.
Mr. Townsend, you were describing the relationship you had with Laurie. You're having this affair with her, correct?
Correct.
Okay. Tell us about this relationship. What your understanding was with Laurie Shaver.
They're supposed to be friends with benefits, no strings attached.
Friends with benefits. Okay? And yet you're still contemplating a divorce at that time, correct?
Correct.
Okay, so there was a discussion.
A discussion about what?
Now, your position is you had no knowledge of Michael Shaver being shot, correct?
Correct.
Okay. You weren't in the house, correct?
Correct.
Now, you knew the Shaver children, correct?
I didn't know them, like, on a personal basis. I knew she had children. I only seen them a handful of times.
Okay. A handful of times. You're there 2-3 times a week, okay?
The kids were in school.
Now, you're there at their Christmas break, correct?
The kids were not there. They're in school.
Okay, during their Christmas break.
I wasn't there during Christmas break.
When was Michael shot?
I don't know that.
Okay. Did you ever make a statement indicating to the contrary? I'm going to show you your deposition again, sir.
I know what I told you.
Okay.
Yes, sir.
Page 16, I want you to read line 3 through 7 to yourself.
Yeah.
Finished?
Huh?
Okay. Your position was, I have no evidence that I was nowhere near during the time frame or whatever happened to Michael. So now you're saying, I don't know when he was shot, but I know I wasn't around there during that time frame.
Correct.
Right? So you're saying, I don't know when this man shot, but you can't pin it on me.
But if you read farther, I said that
Is that what you just said?
Your Honor, objection. We're trying to answer the question.
No, you can rehabilitate your own witness.
All right, and Mr. Wiggs is correct. So please answer the question directly, and once the question's asked, answer it directly, and then move on. Thank you.
Right? So you don't know when he was killed, but you're saying you can't pin it on me. I was nowhere around without knowledge when he was killed. Correct, sir? That's what you stated in your deposition.
no, it's not.
I just read it to you. You just read it yourself.
But like I said, if you read farther,
Sir, that's what you said, right?
Your Honor, can we approach with the transcript?
Sidebar, please.
Did the state advise you of a date that Michael Shaver was shot?
No.
Okay. One moment, please, Judge.
Yes, sir.
Mr. Townsend, did you get a tattoo in 2016?
No, I did not.
Do you have any tattoos at all?
I do.
Okay, would you describe them?
It's an Indian dress chief with a compass and a map.
Anything else?
Roses.
Do you ever roses? Tell me about that one.
The roses are in the tattoo.
Okay, what's the full tattoo?
I just described it.
Pardon me, speak up.
I just described it.
You said it's roses in a tattoo. What's the full tattoo?
It's an Indian chief with a map and a compass.
Okay. Did you see Miss Shaver at the store in 2016 approach her to show her your new tattoo?
No.
Okay. You never did that, correct? Okay. One moment, please. Mr. Townsend, your family own any property in Silver Springs area?
No.
Okay, do you have parents in Ocala?
No.
Okay, you have any parents in the state of Florida?
Yes, I do.
Where do they reside?
Crystal River.
Crystal River, okay. They own any land?
That their house is on.
Yeah. How much land?
5 acres.
Okay. All right, that's all I have. Thank you, Judge.
All right, thank you. State?
Getting back to the, whether or not you've made a prior inconsistent statement about knowing when Michael Shaver was killed, let me show you your deposition transcript. And can you just go ahead and,
Judge, that's improper rehabilitation.
Sustained, please ask the question. If the question isn't asked properly, then you can approach the witness with the deposition. Please inquire.
did you, in that deposition, tell Mr. Wiggs repeatedly that you do not know when Michael Shaver was killed?
Correct.
And that statement that Mr. Wiggs was reading about, I have evidence that I was nowhere near during the time frame or whatever happened to Michael Shaver, did you say at least 4 times after that that you did not know when he was shot?
Correct.
As far as September, your memory about when you first met Ms. Shaver at deposition, you said you didn't remember, and today you said that you first met her in the park in September of 2015. So what happened in between the deposition and today that helped with your memory?
Went back through all the old text messages to refresh my memory because this is 9, going on almost 10 years ago. I don't remember everything I did during that period of time. So to refresh myself, if I was asked that question, I would know how to answer it. So I went back through all the old text messages and figured out when I seen Ms. Shaver.
Nothing further, Judge.
All right, thank you. Mr. Wiggs?
Nothing further. Thank you, Judge.
Thank you. And may the witness be released from his subpoena.
Yes, sir.
All right. Thank you for testifying today, sir. You're released from further testimony. Have a good day. Yes, sir. Please call your next witness.
State recalls Detective Jared Strickland.
right, good morning. Please come up to the witness stand. Please make yourself comfortable. Let me know when you're ready to proceed. All set? Okay, please state and spell your full legal name.
Jared Strickland, Jarrod-Strickland.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please proceed.
One moment. Got my monitor off. All right, Detective, can you just reintroduce yourself to the jury?
Sure. Good morning. Corporal Jared Strickland with the Lake County Sheriff's Office.
All right. Now, going back, talking more about the Facebook records that you analyzed.
Sure.
And just as a quick reminder, how many different IP addresses were shared with the Michael Shaver account and the Laurie Shaver account over that 2-year period that you analyzed?
There were 13 IP addresses between the two.
And looking at Laurie Shaver's Facebook records first, shortly after Mike Shaver's disappearance in November of 2015, was there record activity showing Laurie Shaver basically returning on to Facebook or becoming active on Facebook again?
Yes, there was.
And specifically, what indicated that when you went through it?
There was a photo of her that was posted, a selfie that she took of herself, and the comments that were on that photo were essentially saying things like, "Welcome back, it's been a while, happy to see you back."
The state is showing defense what has been previously been marked for identification of states RR. Witness states RR. Do you recognize that exhibit?
Yes, I do.
And what is that exhibit?
This is a selfie photo of Laurie Shaver.
Is that the one that we just discussed?
Yes, it is.
And was that taken from the actual Laurie Shaver Facebook records that are already in evidence?
Yes, it was.
All right, this time the state moves states RR into evidence in states 46.
Any-
You can object on 90.401 and the objections as raised in our motion to exclude digital data.
All right. Objections overruled. States RR will be entered into evidence as states number 46.
Go ahead and publish. What was the date of this selfie post and the comments about the your back?
November 11th, 2015.
Now, on November 11th, 2015, did she make another post?
Yes, she did.
And what type of post was that?
It was a status update, so it was just basically words that she typed.
State is showing defense was previously been marked against state's exhibit SS for identification. Showing the witness states SS. Is this the status that you referred to?
Yes, it is.
And is that taken from the Laurie Shaver Facebook records that are already in evidence?
Yes, it was.
The state would move states 40 SS in evidence to states 47.
Any objection?
Same objection, Judge.
All right, objections overruled. State's SS will be admitted into evidence as state's number 47.
Go ahead. And can you go ahead and read that status?
Of course. Sending a huge thank you for those who've served our country, my dad, grandfathers, and to my brave, loving man. Can't get any braver than those men and women. So much respect.
And as the course of the investigation, was there ever any indication that her husband, Michael Shaver, was in the military?
No.
Was there ever any indication that her boyfriend at this time, Jeremy Townsend, was in the military?
Yes.
And what is the significance of November 11th, 2015?
It's Veterans Day.
Over the next couple of months, did she post anything on Facebook regarding her workouts or physical activity?
Yes, she did.
Showing defense what has been previously marked for identification as states TT, UU, and VV. Showing witness states TT for identification. You recognize that post, TT
Yep.
specifically. And
Yes, I do.
what is that post?
It's a photo of Laurie Shaver on it looks like a weight bench.
And it was that from her Facebook records that were previously entered into evidence.
Yes, it was.
And states UU, what is that?
Also a selfie photo of Laurie Shaver in a vehicle wearing workout clothes.
And does it reference in the content of that going to having something to do with workout without reading what it is?
Yes, it does.
And what about states VV?
It's a photo of a workout machine in a barn or a shed.
Now, are all three of those from the Laurie Shaver Facebook records that we've been talking about and are previously in evidence?
Yes, it was.
At this time, Your Honor, the state removed states TT into evidence as 48, UU into evidence as 49, and VV into evidence as states 50.
Any objection? Objections are overruled. As to the three exhibits, states TT will be entered into evidence as states number 48, states UU will be entered into evidence as states number 49, and states VV will be entered into evidence as states number 50.
Very quickly, before we move on to publishing those photos, I do want to go back to the activity from November 11th, 2015. Based on review of the IP logs, was there any other activity other than posting photos or status updates associated with that date?
Yes.
And what was that?
Michael Shaver's activity also, I believe.
Was there anything on Laurie Shaver's IP logs and that is already in evidence that refers to her changing her Facebook profile name?
Yes, her name was changed.
And I'm showing a page from the IP summary. Can you just step down and indicate to the jury where that is and tell them what page number that is on this from the summary?
So again, same as yesterday, month, date, IP address, activity on the Shaver account, activity on the, Mike Shaver account, Laurie Shaver account. On November 11th, 2015, the action on Laurie Shaver's account shows a name change.
And thank you very much. That was from you. Go ahead and have a seat. I'm going ahead and publishing states 47, previously marked as TT. Is this the workout picture that you referenced?
Yes.
And can you go ahead and read the post associated with that?
Slowly getting back into the weights and was happy to see these muscles come back alive today. Smile through the pain.
Go ahead and publish the statements. 49, what was the status posted there?
Mentally preparing myself for leg day with the most awesome personal trainer. Not gonna lie, I'm a bit scared. It's a love-hate relationship. She makes me swear, LOL, and I don't do that often.
What date was that posted?
January 2nd, 2016.
And finally, the cable machine, when was that posted?
May 14th, 2016.
Also contained in the Laurie Shaver Facebook records was their photographs and other posts associated with her engagement to Travis Filmer.
Yes.
Was there also photographs associated with the ceremony that occurred on December 31st, 2016 between herself and Mr. Filmer?
Yes.
I'm showing the defense what has been previously been marked as states SSS for identification. Showing what is states SSS. You recognize that post.
Yes, I do.
And is that post from the Laurie Shaver Facebook records that is already in evidence?
Yes, it is.
Your Honor, this time the state moves states SSS into evidence as states number 51.
Same objection, Judge.
Right, objections overruled. States SSS will be entered into evidence as states number 51.
Go ahead and publish. And first of all, can you read the date that this was posted?
August 12th, 2016.
And was there any sort of message that was associated with these photographs that were posted?
Yes, there was.
And what was that?
God has gifted us with a great blessing, that of bringing us together. We are excited to now publicly announce we are engaged. We have appreciated all the love and excitement from our close friends and family. We are so blessed. I'm going to be a filmer.
And what date was that?
That was August 12th, 2016.
Were there also posts associated with the installation of the fire pit and ultimate cement slab?
Yes.
I'm showing you what has been previously been marked as states WW. Show it to the fence. You recognize that post and series of photographs.
Yes, I do.
And were those taken from the Laurie Shaver Facebook records that are already in evidence?
Yes, it was.
Your Honor, this time the states moved states WW into evidence at states 52.
Any objection?
Same objection, Judge.
Objections overruled. States WW will be admitted into evidence as states number 52.
Go ahead and publish the photos. First of all, can you say the date that this was posted?
March 24th, 2016.
And what is the content of the post?
Newest project. Built this fire pit today. Cut a portion of the fence for straight access from back porch, and now just need to pour in concrete. Put in a new gate and figure out seating. Going to be a great summer.
Now, go ahead and look at the final photo in there. Do you recognize the children in that?
Yes, I do.
And who are they?
Those are Mike and Laurie Shaver's children.
Thank you very much. She referenced pouring a concrete slab. Were there later posts on her Facebook profile about purchasing some concrete?
Yes, there was.
I'm going to go ahead and show you states XX, show defense. You recognize this post from states XX?
Yes, I do.
Is that related to the purchase of concrete from Laurie Shaver's Facebook profile already in evidence?
Yes, it is.
Your Honor, at this time, the state moves states XX into evidence at states 53.
Any objection?
Same objection, Judge.
All right, sir. Objections overruled. States XX will be admitted into evidence as states number 53.
Go ahead and publish what date is this posted?
April 28th, 2016.
And what is the content of the post?
It was originally a photo of bags of cement in the back of a truck.
Did Laurie Shaver comment on that?
There are comments, yes.
What did Laurie Shaver comment on that?
Yes.
Or what did she say?
Somebody asked what it was. She said cement. It's going in the area around the fire pit I built, going to make a seating area. Somebody else asked, how on earth would you mix and pour that? Don't you need a huge machine? Good luck. Can't wait to see. Laurie Shaver, filmer, posted, nope, a wheelbarrow will do, and you mix with mussels, LMAO.
In the course of your investigation, did you also find evidence of a subsequent purchase of more concrete,
Yes.
showing the defense what has been previously marked as states YY? At this time, the state moves states YY into evidence as with the appropriate business record certification and no intent to rely on such as states 54.
Any objection?
No objection.
Without objection, states YY will be admitted into evidence as states number 54.
Direct your attention. Well, first of all, what is states 54?
These are records that we obtained from Lowe's.
And is there a receipt showing the purchase of concrete by Laurie Shaver within those records?
Yes, there is.
And actually, can you step down and bring that with you if that'll help? First of all, can you indicate here on the receipt where it shows that this is connected with Laurie Shaver?
Has the customer name, Laurie L. Shaver, in the top left?
Okay. And does it have a date that this transaction occurred?
It does.
And what is that?
September 12th, 2016.
And can you indicate on the receipt the concrete?
Sure. 42 bags of 80-pound crack-resistant concrete.
Thanks very much. Have a seat. Shortly after, associated with your search for records about purchase of concrete, did you also look into whether or not any cement-related equipment had been rented by either Laurie Shaver or Travis Filmer from any of the other home improvement stores?
Yes, I did.
And did you find any evidence?
I did.
And what was that?
It was a concrete mixer that was rented from Home Depot by Travis Filmer.
That is already in evidence. Is there, after cement slab around this time.
Yes.
I'm going to go ahead and show you what has been previously been marked for identification. It states ZZ. Showing the witness states ZZ. Do you recognize this exhibit?
Yes, I do.
And what is that a post from Laurie Shaver's Facebook that we've been talking about already in evidence?
Yes, it is.
All right, this time the state move states ZZ into evidence. It states 55.
Any objection?
Same objection, Judge.
Objections overruled. State ZZ will be entered into evidence as states number 55.
Publish. All right, first of all, what is the date of the series of photographs for this post?
September 19th, 2016.
And in the second photograph here, what is being depicted in the photo itself?
The fire pit is visible behind the young girl.
And that ultimately is the cement slab that was covering Michael Shaver's body.
That's correct.
All right, I want to move on to some discussion of the records from Michael Shaver's Facebook account again. Now this photo showing the installation of the cement slab, once again, I just want to be clear, what date was that?
September 19th, 2016.
Did you find activity on Michael Shaver's Facebook after September 19th, 2016?
Yes, I did.
Showing defense. Sorry, defense. Showing the witness was already in evidence. State's Exhibit 11. Publish. What is State's Exhibit 11?
It's a photo of Mike Shaver.
And specifically, is this a photo from Michael Shaver's Facebook records?
Yes, it is.
And what type of photo, what would Facebook categorize this photo as?
This was a profile picture.
What's a profile picture?
So with Facebook, you can post a photo that you want people to see whenever they either search for your name on Facebook or go to your profile. It's the photo that's front and center that people would see whenever they visit your page.
And when was this particular photo posted onto the Mike Shaver Facebook account?
March 8th, 2017.
So about 6 months after that post about the cement slab.
Yes.
Were there other profile pictures posted on Michael Shaver's Facebook profile after the cement slab was poured in September 2016?
Yes, there were.
I'm showing you what was identified as State's Exhibit X. Entered into evidence of State's 12. Publish. When was that profile picture uploaded onto Michael Shaver's Facebook account?
January 2nd, 2018.
And when you viewed this picture, did it seem unusual to you?
It did.
And why was that?
It does not depict Michael Shaver anywhere in it.
So did you do any research into this photograph?
I did.
And what did you do? What did you utilize in order to research this photograph?
Sure. So I used what's called a reverse image search.
What is that?
So anybody can do it. You can save an image to your computer, in this case, this image, and you go to Google and click on a little icon that looks like either a camera or a photo, and you can put that photo in to Google search, and Google will search all of the internet to see if that photo has ever been posted anywhere else.
And did you find indications
Yes, I did.
And what was that?
This photo was posted on a Bloody Mary Mix Company's Instagram page called, I believe it was Redneck Sportsman's Juice.
Now, the Facebook also have something referred to as a cover photo.
Yes, it does.
What is a cover photo?
Similar to a profile photo, the cover photo is like a large banner that's on top of somebody's Facebook profile page. It gives you more area that you can put stuff. Sometimes it can be words, it can basically be anything that you want it to be, but it's just a larger photo that can be posted on your profile page.
I'm showing this fence which has been previously been marked as states BBB for identification. You recognize states BBB.
Yes, I do.
Is that a cover photo taken from the Michael Shaver Facebook profile that is already in evidence?
Yes, it is.
Your Honor, this time the state would move states BBB into evidence as states number
56.
56.
Same objection, Judge.
All right, objection's overruled. And that's V as in Victor?
BBB.
Bravo. Okay. All right. Objection's overruled. States BBB will be entered into evidence as states number 56.
Publish. What date was this cover photo published? Or, published on the page?
November 14th, 2017.
So almost 2 years from his disappearance.
That's correct.
And can you step down? Did you look at the IP log history associated with Michael Shaver and Laurie Shaver's Facebook in and around the time that this was posted?
Sure.
All right, and what activity in and around the date and time of this cover photo posted appeared on Michael Shaver's Facebook?
On November 14th, 2017, the IP addresses are the same. Mike Shaver's account was a login activity that was done at 15:58 coordinated time. Laurie Shaver's account on the same day at 15:59 universal coordinated time, and it was also a login.
So within 2 minutes of each other.
That's correct.
Yeah, go ahead and stay there. Prior to Michael Shaver's disappearance, what was the general content of his Facebook posts?
Mike Shaver's Facebook activity was primarily focused on airplanes.
Did he post pictures of himself, his friends, airplanes, things related to that?
Yes.
And I'm going to ask you, have you ever had reference to something called a meme?
Yes.
And what is a meme?
A meme is typically an image. It has words that have been transposed on top of an image. It's usually designed to be either witty or funny. It can be any picture that anybody wants to take, and they usually become viral and start floating around the internet.
Now, prior to his disappearance in November 2015, did Michael Shaver's Facebook show a lot of meme posts?
Only one that I can recall.
And after his disappearance in November of 2015, did that change?
It did.
I'm showing that's what has been previously marked as states CCC for identification. Showing the witness states CCC for identification. What is that?
The meme that was posted to Mike Shaver's Facebook account.
And that's basically one page from the 3,000 pages that's already in evidence.
That's correct.
Your Honor, the state moves states CCC into evidence as states 57.
Any objection?
Same objection, Judge.
Objection's overruled. States CCC will be entered into evidence as states number 57.
Go ahead and publish. First of all, what was the date of this post?
January 5th, 2016.
And what is the content of the meme itself? What did it say?
Don't take a good woman for granted. Someday, someone will come along and appreciate what you didn't.
Now, did you look at the Facebook activity as far as the IP logs associated with Michael Shaver's Facebook and Laurie Shaver's Facebook for that day?
Yes, I did.
And does that appear on the summary page 9?
Yes, it does.
All right. And what was the activity related to this post on Michael Shaver's Facebook compared to Laurie Shaver's Facebook?
Mike Shaver's account uploaded a photo. Laurie Shaver's account uploaded a photo.
And what were the times of those?
Mike Shaver's was at 16:05 Universal Coordinated Time. Laurie's was at 2:08 Universal Coordinated Time.
But sharing the same IP address.
Correct.
State is showing defense what has been previously been marked as states DDD. Showing witness states DDD. Do you recognize that exhibit?
Yes, I do.
And what is that exhibit?
Also a meme that was posted to Mike Shaver's Facebook account.
Is that from the same Facebook records that we've been talking about?
Yes, it is.
State moves states DDD into evidence in states 58.
Any objection? All right, objections overruled. States DDD will be admitted into evidence as states number 58.
Going to publish. First of all, when was this posted?
January 18th, 2016.
And can you go ahead and just read the content of the meme itself?
Some people need to mind their own business. Hashtag get a life.
Now, was there activity on the same IP address from Michael Shaver and Laurie Shaver's Facebook accounts on that day?
Yes, there was.
And can you go ahead and tell the jury, first of all, when the activity was on Michael Shaver's account?
Sure. January 18th, 2016, 3:35 Universal Coordinated Time. The photo was uploaded. January 18th, 2016, 15:21 Universal Coordinated Time. Photo was uploaded to Laurie Shaver's.
Very much. Now, switching back to Laurie Shaver's Facebook. What was the general, what types of things would be posted on Laurie Shaver's account?
She would publish photos and also memes.
Based on the sheer volume of the records, it's fair to say she put that account was posted to much more frequently.
That's correct.
And the large number of pictures of herself, family, kids, things of that nature.
Yes.
But did she also post memes quite often?
She did.
I'm showing you what's been previously been marked as states EEE, showing to the defense first. Showing witness states EEE. Do you recognize that?
I do.
And is that a post from the Laurie Shaver Facebook records that is already in evidence?
Yes, it is.
All right, this time the state moves states 58 into evidence and states 59.
Same objection, Judge.
All right, so states E, over defense's objection, states EEE will be entered into evidence as states number 59.
Go ahead and publish. First of all, when was this posted?
January 8th, 2016.
And what is the content of the post itself?
The photo says, sometimes you just have to turn around, give a little smile, throw the match, and burn that bridge.
Now, going down further on that same page, is there a reference to the next post?
There is.
And what is the reference to the next post that appears on that page?
Awesome day getting dirty.
What date and time was that posted?
January 8th, 2016 at 0018 Universal Coordinated Time.
And on the following page of the Facebook records, is there there a photograph that's associated with that post?
Yes, there is.
I'm showing the defense what has been previously been marked as states FFF for identification. You recognize states FFF for identification.
Yes, I do.
And what is that?
It's a photo of Laurie Shaver with mud on her shirt.
And is that the next page in the Facebook records that we've been discussing?
Yes, it is.
All right, this time the state moves states FFF into evidence of states 60.
Any objection? Objection is overruled. States FFF will be admitted into evidence as states number 60.
Go ahead and publish. Now, during your review of the Facebook records of Michael Shaver, specifically referring to the photographs that were sent through Michael Shaver's Facebook account to Vanessa Townsend, did you find evidence of photographs contained within there associated with this photo?
Yes, I do.
I'm showing the defense what has been previously been marked as states GGG for identification. Showing witness states GGG. Do you recognize those photographs?
Yes, I do.
And where were those photographs from?
These were from, I believe these were from Laurie's Facebook. Or were these from Michael's Facebook in the images?
Are those from Michael Shaver's Facebook, the images sent to Vanessa Townsend?
They are the images that were sent to Vanessa Townsend.
All right, this time the state moves states GGG into evidence as states 61.
Same objection, Judge.
Objection is overruled. States GGG will be entered into evidence as states number 61.
I'll go ahead and publish. So the photographs on the left and right are from the photos sent to Vanessa Townsend, and the photo in the middle is the picture from Laurie Shaver's Facebook profile.
That's correct.
Returning to Michael Shaver's Facebook, as you were going through, other than that photo from the bar, were there other photos, was there another photo that drew some suspicion from you?
Yes, there was.
And I'm showing defense what has been previously been marked as states III. Showing witness states III. Is that the photo that you found suspicious from the Michael Shaver Facebook account?
Yes, it is.
All right, this time the state moves states III into evidence as states number 62.
Any objection, Mr. Wiggs?
Same objection, Judge.
All right, objections overruled. States III will be admitted into evidence as states number 62.
Go ahead and publish. Is that the photo that we were referring to on the left-hand side?
Yes, it is.
And first of all, why was that suspicious to you?
It, like some of the others, also did not depict Michael Shaver.
All right. And when you had your suspicions, what did you do to look into it?
A reverse Google image search.
And using the same process that you talked about from the bar photograph?
That's correct.
And what did you learn when you did that?
This photo is not original. It's been shared on the internet numerous times.
And when was this posted?
This post was July 25th, 2016.
And was there any other related information that you got from Facebook associated with this post?
Yes, there was.
And what is that?
This photo was uploaded along with a check-in location.
What is a check-in location?
So Facebook
actually have to physically be at that location in order to do a Facebook check?
You do not.
And was there information on the IP logs associated with this photograph and the summary?
Yes, there was.
And can you indicate, first of all, are referring to pages 53 and 54 of that summary?
July 25th, there's the IP address, along with another IP address that was also used in the same time frame. Mike Shaver's account with a login, and then also an action photo upload.
And was there activity on Laurie Shaver's Facebook utilizing the same IP address?
Yes, there was a password change.
And what is the time, first of all, the time of the Michael Shaver Facebook profile associated with this check-in in the middle of Lake Okeechobee?
Mike Shaver's account was on 7/25/2016 at 13:10 Universal Coordinated Time. The
Are the parties ready for the jurors?
Yes, sir.
Okay, please bring in the jurors. Please be seated. I see that all of the members of the jury have returned. Please proceed.
Now, as you were going through Michael Shaver's Facebook profile and focusing on the messages and screenshots of text messages sent from Michael Shaver's Facebook to Vanessa Townsend, did you find screen captures of text messages between Jeremy Townsend and Laurie Shaver where they appeared to be in some sort of argument?
Yes, I did.
And going to go ahead and publish, go ahead and step down again. What was the time frame of these text messages?
February 23rd, 2016.
And taking that information, did you then look at the messages sent from the Michael Shaver first message that was sent to Vanessa Townsend, basically indicating that the person with that account wanted to speak with Vanessa.
Yes.
Going ahead and pulling up that portion of the records, when was that attempt to reach out to Vanessa done?
February 25th, 2016.
Going to go ahead and get away from Facebook now. We're going to move to financial records. Did you get, we talked about getting records for Laurie Shaver's bank accounts and checking accounts. Did you also obtain the information for Michael Shaver's bank accounts?
Yes, I did.
Showing you what's been previously marked as states JJJ, any of those records?
Yes, they are.
All right, this time the state moves states JJJ into evidence with the properly affixed notice of intent to rely on business records certification and business records cert showing to defense.
Judge, the same objection as to relevance, probative value, and authentication, as we stated.
All right, the objections are overruled. Stage JJJ will be admitted into evidence as states number 63.
Now, what time frame of records were obtained?
The records began summer of 2014 until March 2016.
Now, prior to his disappearance in November of 2015, what kind of activity appeared on his financial records, his bank records?
What I refer to as financial transactions indicative of normal everyday life.
What do you mean by that?
Physical locations in stores, retail establishments, restaurants, consistent paychecks, paying for utilities and bills.
And the time frame that we have published here on pages 69 and 71 of the bank records, what time frame are we talking about?
October 28th, 2015 through December 24th, 2015.
Correct. Now, after his basic time frame that he called no show from work in November 10th of 2015, what types of transactions appear on those records?
The transactions are, the purchases at least, are no longer consistent with in-store purchases.
Okay. What types of transactions do we have?
Purchases online as well as ATM withdrawals.
And the ATM withdrawals, do they indicate where those were from?
They do.
And where were they?
Claremont and Disney.
Okay, so nothing from Georgia?
Nothing from Georgia.
And in other investigations, have you been able to go through and try to get video from ATMs and things of that nature?
Yes, I have.
Do they retain that video forever?
They do not.
So when this case came to your attention, had video from ATMs expired due to the 3 years that it had been before the body was even discovered?
Yes, ATM video is typically only held between 30 and 90 days.
And the online purchases, what were those?
There were 2 online purchases to Wish.com.
What is that?
Wish.com is it's a kind of an alternative to Amazon. It's another online e-commerce retailer.
Are they a little more difficult to deal with than Amazon?
They are.
All right. And what was the other online deal?
The other online purchases were for Walmart.com.
Are there any deposits associated with this?
There is.
And what was that?
On December 14th, there was an ATM check deposit at the Citrus Tower Boulevard, assuming Chase, in Claremont for $2,539.
And that amount, is that consistent with other financial records that were obtained in this case?
Yes, it was.
And what was that?
We received a copy of this check from Mariner Finance, payable to Michael Shaver for $2,539.
And is that the same check that is referenced there in States 29?
Yes, it is.
Did you do, after that check was deposited, what were the next transactions? And just go ahead and read the dates and what they were and the amounts.
The check was deposited on December 14th. On posting date December 14th, there was a $100 withdrawal in Disney. On December 14th, there was a $200 cash withdrawal from the Citrus Tower in Claremont. On December 18th, there was another ATM withdrawal for $500, also from Citrus Tower Boulevard in Claremont. On December 21st, there was a withdrawal in Groveland for $400. On December 21st, an ATM withdrawal for $500 from Citrus Tower. And then on December 23rd, another ATM withdrawal from Citrus Tower for $500.
Now, moving on to page 71, is this the page that references the transaction with Walmart.com?
Yes, it is.
And can you go ahead and just point to it, say the date and what that transaction was?
December 23rd, card purchase. The transaction date that's listed in the description of the transaction is the 22nd, Walmart.com, $397.16.
And did you do research into, with Walmart, into the source of, or basically what was purchased and where that was sent?
Yes, I did.
I'm showing you what's been previously been marked as states, well, showing defense was previously marked as states LLL for identification. Showing the witness states LLL for identification. Do you recognize that document?
Yes, I do.
And are those the records that you received from Walmart?
Yes, they are.
At this time, the state moves states LLL in as a business record with the valid notice of intent to rely on business record certification, along with the valid business record affidavit.
Any objection?
Judge, same objection. Stand.
Objections overruled. States LLL will be admitted into evidence of states number 64.
Now, included with that exhibit, do you have is there the printout from Walmart along with the disc?
Yes, there is.
And this information that you received from Walmart, did it come to you electronically?
Yes, it did.
And is it easier to read the original electronic PDF as opposed to the version that is printed out?
Yes, it is.
All right, this time I'll publish.
Yes, sir.
Go ahead and use the CD. Now, there's two documents on this CD. I'll pull up the first one first. this is pulling up, can you go ahead and go into the bank records, the areas with the Walmart transaction? So as we go on here, what information is contained in this first page records?
This is the order summary for the Walmart purchase that was made.
Right. And first of all, who is showing from the Walmart records as the purchaser?
Laurie Shaver.
And where does it show that this purchase was delivered? Is that on this page?
Right here, as well as right here.
And up here at the bottom, what is indicated here as far as the actual purchase itself?
These are the purchase amounts, as well as the date and time.
And is the purchase amount located on the bottom here consistent with what was from the Mike Shaver Facebook records?
Yes, it is.
I mean, sorry, not Facebook records, the bank records. And that also indicates how it was paid,
Yes,
and is that associated with his credit card?
correct.
Going on to the other pages. This includes billing information, other things associated with the Walmart.com transactions.
Yes, it is.
And once again, who is shown as the purchaser?
Laurie Shaver.
This include information about other purchases.
These are the items that were purchased.
And what was the types of items that were purchased?
From looking at them with the close proximity to Christmas, I believe that they were Christmas gifts.
Looking at Michael Shaver's bank records, was there any activity whatsoever past December 15th, 2015?
No, there was not.
Your Honor, the state has no further questions at this time.
All right, Mr. Wiggs.
Mr. Strickland, or Officer Strickland, all the data that you introduced, all of it that's been discussed so far, does any of it mention a homicide?
I will repeat what I said yesterday. When
That's a yes or a no. Does it mention a homicide?
the word homicide does not appear in those records.
Correct. Okay. Does any of the records that you've introduced, do they discuss aiding and assisting somebody from being detected?
To repeat what I said yesterday,
Do they mention anything about preventing somebody from being detected?
not as you've quoted.
Correct. Okay. Now, you've spoken about financial records. You've shown photographs of Lori with blood on her, correct?
With what?
Blood on a shirt or so?
Yes.
Did you go through the financial records, for instance, and link that up for any particular purpose?
Which part?
Well, the mud on the shirt.
Yes, I did.
Okay. What's the mud represent?
The mud was the day that her and Jeremy went to Revolution Off-Road on State Road 33 in Groveland.
Did you suggest that to the jury in direct examination?
There were purchases made.
Did you suggest that on direct examination?
That wasn't asked.
Right, that wasn't asked. Okay? That, in fact, was not any implication that she had dug a grave or buried Michael Shaver, correct?
No, sir.
about or you showed images of Laurie working out. Okay. Any of the Facebook data that you look at indicate her being involved with Beachbody sales?
I have no idea what that is.
Okay. Any of it indicate, did you look through each and every document indicating why she may be working out?
Seems like she enjoyed it.
Yeah, a lot of people like to work out.
Sure.
Correct? Doesn't suggest necessarily they're planning a homicide, does it?
To repeat what I said yesterday,
Or does it necessarily imply somebody's planning a murder?
no, it does not.
Okay. You talk about this Facebook account being accessed and that Facebook account and it being Laurie and Michael's, correct?
Yes,
Okay. More than one person could have accessed that account, correct?
sure,
More than Laurie Shaver, correct?
sure.
If anybody was in the house, Jeremy Townsend, he testified he would be in the house, he may have been able to access those accounts, correct?
Theoretically,
And there's been no link-up testimony between the IP, the physical residence, and any device, correct?
incorrect.
Okay. Didn't you testify yesterday that these IP addresses expire over time? Was that your testimony?
Not that they expire every time. No, my testimony yesterday was that those records were only held by CenturyLink for a rolling 12 months.
And that there's no preservation of the IP address after a period of time,
Not for CenturyLink.
correct? Facebook, do they internally keep the IP addresses?
They do.
In perpetuity?
They do.
Okay. Do any of the records that you've spoken about show causation of a homicide?
To repeat what I said yesterday,
Sir, I'm not asking you to repeat what you said yesterday. Do any of them show and reveal causation of a homicide?
define causation.
The manner of?
Those records did not know.
Correct. You mentioned about banking records. Laurie Shaver's not on trial for bank fraud or any such charge like that, is she?
No, she's not.
You mentioned memes that were posted, correct?
I did.
And one was introduced and it said, I think, something like, sometimes you have to burn the house down and move on, correct?
The bridge.
Bridge, correct, okay, and move on, okay? That's an expression, correct?
It is.
Did you find any bridge burnt down or anything like that that was relevant?
An actual literal bridge, sir? No, sir, I did not.
And these memes that you've testified to or have been presented are just standard phraseology, correct? This isn't a personal thing somebody's created necessarily.
Well, they can be.
Okay. Do you know who created these?
I do not. I didn't look into that.
Okay. You do these searches where you can look at photos and see if they're posted anywhere else.
Sure.
Do you know if Laurie Shaver created that meme, any single meme?
I do not.
Correct. And going back to all the records that you've spoken about that have been just ushered into evidence at this stage, you're unable to account for any specific number of images to say, this definitely came from Laurie, this came from this person, this came from this person, correct?
I don't believe so.
One moment, please, Judge.
Yes, sir. Thank you. Redirect.
When you're referencing Facebook maintaining IP records in perpetuity, is that how you were able to get the information from Facebook and create where that summary was created from?
That's where those records came from. I have no idea what their retention period is.
And then, so for at least the period of time that you asked for, they were able to give you the IP addresses associated with all of those posts.
Yes, they were.
And now CenturyLink and who would be the one that might know or would know who the physical address was attached to those different IP addresses, they have nothing to do with Facebook and vice versa. They're
That's-
two separate entities.
That is correct.
Nothing further, Joe.
Okay, just on this IP issue, just for clarity, Facebook may hold the IP, but that IP is not linkable to a physical address over time.
Objection.
Not with the Facebook.
Pardon me?
Overruled. You may answer.
Not with the Facebook records.
Correct.
Nothing further, Judge.
All right. And may the witness be released from his subpoena.
He is subject to recall, but he can step down today.
All right, sir. You may step down from the witness stand. You're subject to recall. Please be available. Thank you, sir. Okay. And your next witness.
Your Honor, at this time, the state of Florida rested its case against Laurie Shaver.
All right. Deputy, please take the jurors out. Thank you.
We had discussed previously circumstantial evidence in any criminal case, how it could be used and the boundaries of it. We had cited to the court previously Smith versus Carlisle. That decision is cited at 378 Southern 3rd, 1213. It's a 5th DCA decision quoting extensive language on history of stacking inferences. What I announced for the court previously is the history of stacking inferences started with Knight. It was further represented in Sims and Law and numerous other cases. And back in earlier era, that when those cases were effective, the law declared that the state could not rely on stacking inferences of guilt to try to reach an ultimate decision on the state's behalf. Later in Carlisle, Smith versus Carlisle, that decision did away with that same principle. And it stated that stacking inferences was permissible at this day and age. But what it did is it went back to an earlier principle, which is the Volcker decision, and that's cited at 70 Southern 2nd 403. And that is a Supreme Court of Florida decision, 1954. And what Smith stated was, citing from Volcker, which recited the criminal principle at that stage. It states that stacking one inference upon another as a method of establishing an ultimate fact ordinarily should not be indulged in unless the first inference meets a test which may be analogized to the criminal rule concerning circumstantial evidence. And the court went on to say, well, what the criminal rule is. And it says, only if the prior or basic inference is established to the exclusion of any other reasonable theory, then you may stack inferences upon another. I've repeatedly approached the bench, to the annoyance of probably everybody observing and within the court, to preserve this issue for an appeal, and declared that there's no basic inference that the state has at any time stated in this courtroom that they're going to try to declare all the other inferences dependent and stackable, so to speak. So I've raised that and preserved it through this trial. At no time has the state announced any primary basic inference not subject to reasonable dispute. Without that basic inference, then stacking inferences becomes impermissible under the law. And the Volcker decision supports that principle. That would be one of the grounds for exclusion. Second, without stacking, with impermissible stacking, the state has never established causation. They have established that there's a dead body. They haven't established that Laurie Shaver is responsible for the dead body. They allege that we have a body and there's been some form of a cover-up. Now, the state again relies on circumstantial evidence and trying to stack inferences without a primary inference to rely on to declare that the crime was committed and it has to be associated with Laurie Shaver to the exclusion of the rest of the world. We know there's been inconsistent testimony on that point. There's been acknowledgement by the state's own witnesses that devices can be hacked. They can be accessed by other people within a remote vicinity or within the access of the router, and it doesn't exclusively declare that Laurie Shaver thus is reliable for any homicide. The next thing the state attempted to do was to say, here's a body on a ground in a grave, and yet there's no evidence in any form or manner that ties to Laurie Shaver. So the only thing they're doing is trying to use a bunch of unsupportable inferences from the digital data, which isn't linkable. It doesn't make any mention of a death, a homicide, or a cover-up, to say simply you could have a motive and you may have committed the crime. That's insufficient evidence under the law. But we know as well, when we look at the physical scene, be it the gravesite, there's no DNA, there's no signature of a crime, there's no prints, there's no forensic data or evidence of any kind. We know there's no connective link between the grave and the home site. There's nothing found within the home site that suggests Laurie Shaver transported the body, committed the homicide, or responsible in any manner whatsoever. So the state has failed to establish circumstantially and forensically that Laurie Shaver is responsible for the crime. We've moved judge for a judgment of acquittal based on those grounds, state that the state is not supported, the state has not supplied a case with competent substantial evidence for the matter to proceed forward to a jury. And on those bases, we'd ask that request.
Thank you. State?
Your Honor, Mr. Wiggs is misinterpreting the case he's citing as far as Smith v. Carlisle. Once again, this is a civil case. Smith v. Carlisle states specifically, as it refers to the prior Volcker decision that Mr. Wiggs also is relying on, and this whole stacking one inference upon another, which Mr. Wiggs' argument relies. In the Smith case, it specifically says, the standard of review in entirely circumstantial criminal cases has now been discarded by the Supreme Court, which accurately described the rule as confusing and an outlier in federal and state courts. See Bush v. State 295 Southern 3rd. It goes on to say, in Bush, the court upheld a death sentence based entirely on circumstantial evidence and goes on to describe how the Florida Supreme Court is going away from the previous decisions in Knight and the other cases of which Mr. Wiggs's argument relies on. It says, and the Supreme Court in Bush relied on the United States Supreme Court rationale in Holland v. United States in order to come to that conclusion. This is a quote from the Supreme Court's decision in Holland. Circumstantial evidence is extrinsically no different from testimonial evidence. Admittedly, circumstantial evidence may in some cases point to a wholly incorrect result, yet this is equally true of testimonial evidence. In both instances, a jury is asked to weigh the chances that the evidence correctly points to guilt against the possibility of inaccuracy or ambiguous inference. In both, the jury must use its experience with people and events in weighing the probabilities. If the jury is convinced beyond a reasonable doubt, we can require no more. The Smith v. Carlisle case talks about how the court eliminated the special instruction regarding the circumstantial evidence case, and the Smith v. Carlisle case concludes by saying that it would hold also to defy reason to hold that a person can be sentenced to the ultimate penalty under the law of death based solely on circumstantial evidence that does not exclude every reasonable hypothesis of innocence, but a plaintiff cannot survive a motion for summary judgment in a civil case based on circumstantial evidence alone. It goes on to basically say that this current civil standard makes no sense in light of the Florida Supreme Court's criminal standard in Bush, but says that for it to be ultimately resolved in a civil context, the Florida Supreme Court will have to weigh in on whether or not Volcker still stands in a civil setting. Smith v. Carlisle and Volcker have absolutely nothing to do with this court's analysis whatsoever, and the Smith case says that. What matters is what the Florida Supreme Court said in Bush v. State 295 Southern 3rd 179 in May of 2020, where it said because this special standard, and this is talking about the overcoming all reasonable hypothesis of innocence, because this special standard is unwarranted, confusing, and out of sync with both the jury instructions currently used in this state and the approach to appellate review used by the vast majority of the courts in this country, we discontinue its use. The Bush case, and I do have copies of Bush as well as Smith v. Carlisle, for your honor. Can I approach?
Yes, sir. Come on up. Thank you.
Quotes the same United States Supreme Court decision in Holland, which supports that there needs to be no special review by the judge in circumstantial evidence cases to determine whether or not all reasonable hypotheses of innocence have been overcome. This stacking inferences upon another is not the standard whatsoever. We have presented, despite Mr. Wiggs's assertions, we have absolutely shown evidence of causation. The cause and manner of death was established as gunshot wound, and the fact that the manner of death was homicide. The circumstantial evidence in this case shows that Ms. Shaver was the only person with the means, motive, opportunity to carry this out. She is the fact that the body was buried in her backyard shows that this was, as Detective Tamara Dale stated, not some robbery on I-4. The various evidence presented through bank records, Facebook records, phone records has established that Ms. Shaver has actively prevented the discovery of this body for years. Posed as Michael Shaver, used his bank accounts, used his phone, changed his phone number in order to try to manipulate Vanessa Townsend, changed that phone number again to a phone number associated with her. She's had access to his Facebook, access to his phone, access to his bank, actively covered up his death, lied about it to friends, family members, and law enforcement. She has a firearm that is consistent with all class characteristics and as caliber as the projectile found in the skull. The state has presented more than enough evidence for this to go to the jury.
All right, anything further?
Judge.
Yes, sir.
No, Judge, opposing counsel has this wrong. He miscites the Bush case. The case I cited, Smith versus Carlo, is subsequent to Bush. It talks about Bush and what it was, and it talks about that Volcker was a civil case, but it indulged the analysis from a criminal perspective. And that's the very language it says. Stacking one inference upon another as a method of establishing an ultimate fact ordinarily should not be indulged in unless the first inference meets a test. So here's the new test. Because Bush did away with stacking inferences, it goes back to the former test, which is Volcker. And it says, only if, referring to the criminal standard, they say, only if the prior or basic inference is established, there's no been basic inference established here at this trial, to the exclusion of any other reasonable theory. Okay? That's what it says. So counsel can say, well, that's a civil case, but it's quoting a criminal standard all through it. I submit these cases to the court.
All right, please approach.
The state takes a posture that somebody buried in a yard must have been the closest body to it, must have killed the person. Okay? We know Jeremy Townsend was at the residence from his own testimony. There's no such standard by proximity equals knowledge, equals homicide. There's no case that's going to be supportive of the theory that the state would advance here today. Likewise, all the physical evidence, each and every piece of it, does not implicate Laurie Shaver. I submitted to the court a proposed jury instruction. That decision was Bowen. And I submitted to your offer to the state as well. And it says, knowledge of a crime, even if you know a crime's committed, doesn't mean you have to report the crime. The state takes a different posture here at this motion hearing and states that due to the fact she didn't report it, due to the fact that she covered it up and may have misrepresented it, she must be the person that committed the crime. Well, that's contrary to the laws I've supplied to this court in the Bowen decision. And the state can't contradict that. The state can't contradict the fact that there's no forensic evidence, no ballistics, nothing to paint the picture that only Laurie Shaver committed this crime to the exclusion of the rest of the world. A reasonable doubt exists in a multitude of different fashions, as has arisen in this case, and it is not sufficient on these facts to submit the matter to the jury. Thank you, Judge.
Thank you, sir. All right, when viewed in a light most favorable to the state, the evidence does establish a prima facie case sufficient to support a conviction as to each count in the information. The motion is respectfully denied.
Thank you, Judge.
Thank you. All right, and Mr. Wiggs, does your client intend to testify?
I won't know at this stage, but shortly. Okay.
Okay. And how many witnesses do you intend to call?
Well, we would have, King approach.
Yes, sir. Ms. Filmer, formerly Ms. Shaver, are you satisfied with the services that your attorney has rendered so far? Okay. Is there anything else that you would like your attorney to do in his representation of you? Okay. Just into the microphone, if you could, a little louder so we can, please turn it so it faces you. Thank you.
No, I'm satisfied up to this point, yes.
Okay. Are there any other witnesses that you would like your attorney to call other than what you plan to call this afternoon, other than who you plan to call this afternoon?
No, I don't believe so.
Okay. All right. Are there any other concerns that you would like to voice at this point? Okay. And you are completely satisfied with the services that Mr. Wiggs has rendered thus far. Is that correct?
Yes, Your Honor.
Okay. Thank you. All right. And we'll call the jurors back in and let them know that we're going to break for lunch. It's 11:45. We'll ask them to return at 1 p.m. All right. Is that agreeable with everyone? Okay. Please call the jurors back in. All right, please be seated. I see that all of the members of the jury have returned, and thank you for your time and patience today. It is now 11:45. We're going to break for lunch, so it asks that you all return to the jury assembly room by 1 p.m. Okay, all right, well, have a good lunch, and we'll see you back at 1 o'clock. Thank you. All right, is there anything further before we break for lunch?
Thank you, Judge.
Okay, please return at 1:15. Thank you. We're in recess.
On behalf of Laurie Shaver, Ms. Shaver is seated to my right.
All right, Ms. Shaver, you remain sworn. Any preliminary matters before we call the jurors back in?
Just a couple matters.
Okay.
We had raised a motion for judgment of acquittal.
Yes, sir.
Because that's such a sensitive matter with the district court, I just want to make sure I have all issues on that. We had filed multiple motions with regards to this cause. There had been a motion to exclude any reference to the sale of any firearms. We had cited the authority in there, Agathis and some other authority, to prevent any discussion about that. The court declined to grant that, and there was discussion about that. There was issues about the handwritings, the cards that Ms. Townsend testified to. We filed a motion to exclude those on the basis that there was nobody here to authenticate them as to any writing in the form of handwriting analysis. The court declined to grant that, and those cards were discussed. There was a motion to exclude the digital data that was extensive in this case. There was an extensive setup as to the authority and the proper predicate. No predicate was laid in this case, and the court just authorized the use of a business record. With regard to that motion as well, there was a case of Chanel cited within it, talked about when data is passed from one corporate entity into another, there has to be an analysis to the reliability from one corporation to the next. There was no such analysis the court permitted introduction of that. Let's see. There was previously a Williams rule notice that was filed in this case. I understand the ruling of that decision. What we had asked, though, was that the minor child be able to talk a little bit more in detail about specific acts of misconduct, and as much that it shaped her reaction and motive as to this cause and why she felt the need to exercise self-defense. Looking at the self-defense jury instructions and the standard instructions, counsel would point out to the court there is a section in there that deal with prior bad acts and the instructions themselves. We've presented to the court a proposed instruction and have outlined the relevant acts in this case that would be subject for consideration. We still ask that those bad acts be considered in a different format, which we anticipate to introduce in this matter through the introduction of the testimony of Isabel Shaver. But I just want to add those to the motion for judgment of acquittal to remain subject.
Yes, sir. Is there anything from the state?
Yes, sir.
All right, the prior judgment on the motion for judgment of acquittal stands. The motion is respectfully denied.
The defense would first call Adam Narvaez.
All right, well, we'll call the jurors in first, but are there any specific issues concerning that witness?
Just the issues, the pretrial motion.
Sir? Yes, sir. Okay, nothing additional then. All right, then we'll call the jurors back in. Thank you. Please be seated. I see that all of the members of the jury have returned after lunch. Defense, you may proceed.
Yes, thank you, Madam. Please support.
Yes, sir.
Defense would call Adam Narvaez.
Okay. Good afternoon. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Adam Narvaez, ADAMNARVAEZ.
All right, please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Mr. Narvaez, I say Narvaez, I think you say
Narvaez.
Narvaez. Okay. And you've spelled your name on the record. Let me ask you, what do you do for a living?
Right now, entrepreneur. I own several businesses.
What are such businesses?
I own a construction company, granite countertop company, a real estate investment company.
Do you know the Shavers?
I do.
Okay. Tell us how you know the Shavers.
I met Laurie through Travis, who's an employee of mine, several years ago.
Does Travis work for you?
Yes, sir, he does.
Does Laurie work for you?
Yes, sir, she does.
Do you have any extended relationship with that family?
Yeah, I mean, it's been a few years now. You know, as you can imagine, specifically with Travis, it's, you know, Monday through Friday, every single day. Yeah.
What does Travis do for you?
Gosh, Travis does a little bit of everything. He's definitely one of my lead guys for Legacy Construction, kind of a project manager.
And does Laurie Shaver work with you?
Yes, sir, she does.
Are you familiar with the other residents of that family?
Yes, sir, I am.
Do you remember when, do you have any recollection of when Laurie was arrested on this case?
Vaguely. Very, very rough with dates, but vaguely.
Did you have the occasion subsequent to her arrest to speak to Adam, any of the family members?
Yes, sir.
And did you have the occasion to speak with Isabel Shaver?
I did.
Without discussing the contents of that conversation, did it raise any concern in your mind?
They did.
And did the concern direct your attention towards the need for independent counsel?
Absolutely.
Were you at any time involved in law enforcement?
Yes, sir, I was. I was a deputy sheriff.
Deputy sheriff?
Yes, sir.
How long did you do that?
Approximately 4 years.
Now, aside from the work relationship, do you have any other relationship or knowledge of this family?
Yeah, we attend some of the same church together. Travis and I go to the same men's meetings together.
When Isabel relayed the information to you that she did,
Yes, sir.
I had filed a motion to retain an independent counsel for her.
Objection, Your Honor. Relevance for this witness's testimony.
If you'll allow me to proceed just a
Overruled,
moment.
please proceed.
There was a financial need in that case for Isabel.
Yes, sir.
Did anybody support that need?
Yes, sir.
And who was that?
I did.
You were willing to take on that financial responsibility?
Absolutely.
And that was Miss Johnson, correct?
Correct.
Miss Johnson was appointed as an attorney ad litem on behalf of Isabel.
Yes, sir.
Have you had any other involvement in this case?
No, sir.
Do you know anything about the reputation in the community about Travis or Laurie Shaver?
Yeah, I mean, in full transparency, I mean, I realize now that this case has gone on for almost a decade, and I wasn't aware of that when I had first met Travis, or when Travis first came to work with me. I don't think necessarily that he was trying to hide it, but it's
Very well.
Sustained.
Let's direct your attention in this manner. Do you know their reputation in the community for truthfulness and veracity?
Truthfulness, absolutely. Veracity, yes, but truthfulness for sure.
As to Travis?
Absolutely.
As to Laurie?
As far as I've known her, yes, sir. I've never had any reason to doubt anything.
As to Isabel?
Absolutely.
Very well. I have no further questions.
All right, thank you. State? Yes, sir.
All the information you talked about regarding Ms. Johnson being appointed to deal with Isabel, that all happened well after Laurie Shaver was arrested for this case, right?
Yes, sir.
Thank you, sir. No other questions, Your Honor.
All right, any follow-up? Okay. And may the witness be excused from his subpoena.
No, you'll be on standby if you don't mind.
All right, sir.
Wait a second. No, that's fine. He's released.
Okay. All right, sir. You're released from further testimony. Have a good day. Thank you for appearing. Your next witness.
Defense would next call Richard Connor.
Please come up to the witness stand. Please be seated. Make yourself comfortable. Let me know when you're ready to proceed. Thank you.
Ready.
All right, please state and spell your full legal name.
Richard Donald Connor Jr., C-O-N-N-O-R.
Okay, first name R-I-C-H-A-R-D.
Yes, sir.
Raise your right hand, please. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Just state your name for the record once again.
Richard Donald Connor Jr.
Mr. Connor, I believe you just retired, correct?
Yes.
Before you retired, you took on this case.
Yes.
That has been going on for a while.
Yes.
Tell the jury why you were retained.
I practice digital and computer forensics, and that includes examining data that's stored online, say with Google, Facebook, Microsoft, Twitter, whatever. And I was retained to examine some data that had been provided in discovery to the defense in this case.
Have you been trained in that area?
Yes.
Have you testified in courts of law as a special skilled witness in that area?
Yes.
Counsel? Judge, if I could show the witness
Yes, sir.
what's marked as Defense Exhibit A for this hearing. You recognize that?
Yes.
Tell the jurors what you're looking at.
It's a copy of my CV.
And that's your curriculum vitae, correct?
Yes.
Does it express therein your training?
Yes.
Does it express therein the trials that you've testified in?
Yes.
Does it testify the period of time in which you've testified and been experienced in this field?
It lists all the cases that I've testified in and the year in which I testified in them. Yes.
Judge, we've moved Defense Exhibit A into identification as Defense 1, I believe, Tess.
Any objection?
CV itself is hearsay. I have no objection to Mr. Potter telling the jury about his credentials, but the CV itself is hearsay.
Judge,
All right.
it provides a narrative for summary for the jury as the state has issued in narratives in this case. In their case in chief, it's an aid and assistance for the jury instead of Mr. Connor going through each page in each case and matter that he's been involved.
And the hearsay issue, what's your response to that?
Yeah, it's a summary instead of him just reading it to the jury, just like the state has admitted summary testimony through their witnesses.
State. Sidebar, please.
Accepted in evidence. Reviewing that document, can you give a summary of the trial matters that you've been involved in and the issues raised therein?
I've testified in trials, depositions, and hearings about 170, 180 cases. State court, federal court, arbitrations, criminal cases, civil cases. In criminal cases, I've done all kinds of murders, child pornography, theft, fraud, drugs, kidnapping, hacking, endless types of cases. In the civil cases, there are even more variety. I'd have to go through them one by one, but it's all over the board, all different kinds of cases, examining all different types of electronic data, usually in computers, hard drives, phones, online, cell phone location data, things of that nature. So like I said, about 180 different cases that I've testified in since 2006.
Have you been qualified to render an opinion in those cases?
Yes.
Judge, we'd ask the court to accept Mr. Connor as a special skilled witness and able to render an opinion in this cause.
Any objection? Without objection, the request is granted.
Okay. Mr. Connor, your experience and computers, were you supplied information in this case to review as it pertains to Laurie Shaver?
Yes.
And did you review all that?
Yes.
You and I had discussions about it, correct?
Yes.
And let's first and foremost clarify, and we have a technological person on this jury, but let's discuss for clarification for everybody else. When we hear the word IP, what is that reference?
Internet protocol. It generally refers to an IP address. Every device that connects to the internet has to have what's called an IP address, and that's what that refers to.
Okay. When somebody goes onto the internet, for instance, do they get a new IP address with each communication, or is there some attachment to the message to identify it?
So the IP address is assigned by your internet provider. So at home or in your office, if you have, say, Comcast, you'll have a modem that allows you and the devices in your home to connect to the internet. And they all go through that modem. And Comcast will assign the IP address to that modem. So anybody within that house, whether it's you, your spouse, your kids, or whatever, they're all going to share the same IP address provided by Comcast. On your cell phone, it's basically the same. And if you have your cell phone and you open your browser and you search for a local restaurant to eat at, I have an AT&T phone. So AT&T is providing me with an IP address to get on the internet and run my search for local restaurants.
And I think this case, you saw CenturyLink records, correct?
Yes.
And that was the router or the phone service that provided the IP addresses, correct?
Yes.
Now, did you see anything, any certificate of authentication for those documents that came back on CenturyLink?
I don't recall.
Now, when these IP address registration that are held by the corporations, do they expire at time? Do they disappear?
So most, an ISP is an internet service provider, in this case CenturyLink, Comcast, AT&T, whatever, and they keep track of who, I'm talking about homes now, not so much cell phones, they keep track of who they assign IP addresses to, but they only keep that information for a limited period of time, normally 1 or 2 years. And then after that, they get rid of it, and they don't have it anymore. So they generally have it, but only for a relatively short period of time of 1 or 2 years.
For a crime that is alleged to have occurred back in 2014, 15, back in that era, were there any IP traceable addresses that existed?
In this case? No, the requests have been made more than, is that me? Outside the retention period. So a request was made to CenturyLink saying who were these IP addresses assigned to, and CenturyLink responded, we don't have those records anymore, it's too much time has passed.
And Facebook, do those IP addresses expire over time?
Not in the same way. Facebook, as long as your account is open, will maintain whatever data is in the account. If you close your account or it becomes inactive, I think after a certain period of time they'll get rid of what they have. But as long as the account is open, then they will not delete anything.
Now, when you have like a Facebook account, does it have to link or be connected to CenturyLink to be able to trace the data where it came from?
No, what happens is Facebook, part of the data that they maintain is the IP addresses used to access the account. So when a search warrant is issued to Facebook And one of the things they'll provide is a list of the IP addresses that are contained within their records of that were used to access the account, the subject of the search warrant.
When you looked at the records in this count, or let me rephrase that question. Without an accurate IP address or one that had expired, are you able to trace the IP address to a IP physical residence?
In this case, no. That's where the expired records come in. Normally, if say the case happened last week and we subpoenaed Facebook today and they came back and said this is the IP address used to access that account, and we can look it up and see it's a CenturyLink IP address owned by CenturyLink. So they would then send a search warrant or subpoena to CenturyLink and say who had that IP address on the date and time identified by Facebook. And then CenturyLink would come back and say it was me or whoever and the address of 123 Main Street in Tavares. So that's how we would know that the modem at that address is the one that was used to access the Facebook account. In this case, CenturyLink said, it's been too long, we don't have the records, so I cannot tell you what address that IP address was assigned to back in 2015 or whatever.
And if they could trace it without that, they couldn't trace it to the residence, correct? I think you just testified to.
Correct. So, like I said, the IP addresses are assigned by the providers. We know with CenturyLink, we don't know who CenturyLink had assigned that IP address to. So it could have been any of their customers anywhere.
Is it fair to say, without being able to trace it to a physical location, you're unable to trace it to the individual at that location?
Correct. We don't have the location, so we don't know who the individual was either.
Is it likewise true and accurate to say if you can't trace it to the location or the individual, you can't trace it to the device?
Correct. There may be other data maintained by Facebook that might identify devices used to access the account, but right, CenturyLink has nothing to identify the device either, I think is what you're asking.
In this case, reviewing the digital data, did you see anything that would trace any digital data to Laurie Shaver in this matter?
No, like I said, CenturyLink did not have records anymore, so that's a dead end in this case.
If a device and somebody is accessing Facebook, are they able to do it in remote locations?
Yes, wherever you have access to the internet, you can access the internet, including Facebook.
Are you able to hack it in another country?
Yes.
Are you able to hack it in another state?
Yes.
Are they able to be hacked and gain access?
It's been known to happen.
If you have knowledge of the password of the account, can you gain access?
There's a good chance, yes.
If there's more than one person inside a residence, can the person use the same router and gain access to that account?
Yes, like I said earlier, the IP address is assigned to the modem or the router in the house, and everybody in the house goes through that modem. So if a search warrant is executed at the house and there's 5 people living there, unless there's other facts in the case, there's no way to know which of the 5 people or which device was being used because the CenturyLink would only identify the IP address of the modem.
If law enforcement can't account for all the individuals that passed through the house and had access to the router as well, or the browser, are they able to access accurately who was on the internet at any specific point in time?
No, not in this case because we don't know the address, so we don't know who was at the address because we don't know the address.
Is one individual capable of going on to another account, another person's account, and posting images of another individual on Facebook?
That's possible, yes.
is anybody able to be within the vicinity of a router at a residence and be able to gain access to it?
Yes, I've had cases like that where somebody short on money and they go to their neighbor in the next house or an apartment upstairs and say, hey, can I bum off your internet? And they say, sure, and give them the name and password. And so as long as you're within range of the signal, you know, somebody sitting on this in their car in the street, maybe a house next door or somebody else in the apartment building, if they know how to get into they know your username and password, they can access your internet, yes.
From a technological perspective, when we hear the word cache associated with a computer, do you know the meaning of that word, or am I missing?
Cache? Cache is temporary data stored on a device. So an example is a web page. When you access a web page normally in your browser, it will cache a copy of that web page so that if later today or tomorrow you go back to that website, it'll actually pull up the cached copy, because that's quicker, while it checks the actual website for any changes, and then it'll update it. So it's temporary data stored on your device. It essentially is what cache is.
One moment, please, Judge.
Yes, sir.
Any further questions? Thank you.
All right, thank you. State? Yes, sir.
Good afternoon, Mr. Connor.
Good afternoon.
An internet service provider is the company that provides the internet access to a house or a business, right?
Yes.
In this case, it's CenturyLink.
Yes.
Spectrum, Verizon, who knows?
Correct.
An IP address is an internet protocol address, correct?
Yes.
They're in the form of 4 digits separated by a period.
Yeah, the IP, was it 4 system? We're moving to the 6 system now or whatever. Yes, you're correct.
Especially back in 2015, would be a 4-digit number.
Yes.
Like 711.49.11.123.
Yes.
That's an address that is assigned to a particular address or a particular location by the internet service provider to give that location internet access.
Yes.
Kind of like a street address that's unique to my house.
Yes.
That internet service provider can change the IP address assigned to that particular house for various reasons, right?
Yes, it's called a dynamic IP address. Most residents have a dynamic one, and it can change. Nobody knows when, but yes, it can change.
It could be the same for a month or 2 months or 6 months, and then they could change it for some reason.
Correct.
That's up to the internet service provider, whatever they do and why they do it.
Correct.
So let's assume I get internet service through Spectrum at my house. Normally, the service provider, Spectrum, would assign me a modem, right?
Yes.
And that's the device that allows the internet to come into my house.
Yes.
Normally, they would assign also a router, right?
Yes.
And a router is a device that allows multiple devices inside a house to connect to the internet at the same time.
Yes.
Every single one of those devices in the house that's connecting to the internet is going to have the same IP address assigned to it, correct?
On the internet side of the equation, yes.
That is what allows me to connect with my cell phone, my laptop, my wife to have her cell phone or her laptop on, connecting to the internet at the same time.
Yes.
And all those devices that are connected to my network are going to have the same exact IP address.
Yes.
So let's assume if you come over to my house for dinner, we're finished with court, you come up and you have dinner with my wife and I. You bring your phone, and after dinner, I log on to my Facebook account and I post a picture. You log on to your Facebook account and you post something, hey, Rich made a great dinner tonight. Because you are on my network, you and I will have the same IP address assigned to that Facebook posting, correct?
Yes, the IP address for both postings will be the same.
And if you left my house and drove down the road such that you couldn't connect to my network anymore, and you went on Facebook, you would be assigned a different IP address.
Correct. Correct.
you're no longer in my close proximity to my network to be able to access it and use my IP address.
Correct.
Now, if somebody remotely from China hacks into my Facebook account and posts a picture on my Facebook account, that's going to log a different IP address than the one assigned to my house, wouldn't it?
Yes.
Because that person would not have access to my network and wouldn't share the same IP address that I normally use.
Yes, in the scenario you're giving us, correct.
Now, conceivably, we ask for, you issue legal service, a search warrant to Facebook. They send the information back to the requester, and that sometimes contains, if requested, all the IP logs associated with the Facebook account.
Correct.
You've seen those records plenty of times, right?
I have.
You reviewed those records and relied on the authenticity of those records in coming to your opinions.
Yes.
Then, assuming we now have the Facebook IP records associated with, say, my account. Conceivably, we could then find out through Spectrum, my service provider, where that IP address, the physical IP address, was assigned to, what location.
Yes, if it's within the year, yes.
Assuming not too much time has elapsed.
Correct.
In this case, because the body wasn't found for several years and the request wasn't made, CenturyLink did not have those physical address links to the IP address because too much time had passed.
Correct. The records have been destroyed or whatever.
You talked a little bit about if someone was in range of a network, they could kind of pirate that network and like sit outside in the driveway and access a person's network and post things, right?
Yes.
That would require that person to A, be close enough to the network to be able to have a signal.
Correct.
B, know the password of that network to even get into it.
Correct.
Would you agree that in this case, the location, the Shaver residence, was in an incredibly rural area, was it not?
To be honest, I have no idea.
So if someone lives on a 5 or 10 acre plot, the chances of somebody sitting outside the driveway and having access to a network is very slim. Would you agree?
It would be, yes, much less slim than in a normal residence neighborhood.
As opposed to if I live in an apartment complex.
Correct.
I want to talk to you a little bit about Facebook. In order to access Facebook, somebody would either need the password associated with the account, right?
Yes.
Or access to a device that was already logged into Facebook such that you could access the Facebook account, right?
Yes.
So right now you would not be able to access my Facebook account through your phone because you don't know my password.
Correct.
Conceivably, my Facebook account wouldn't already be up and active on your phone.
It's not.
Turning to this case, you reviewed the Facebook records of both Laurie Shaver and Michael Shaver's accounts, correct?
Correct.
Those records that you reviewed looked like all the other Facebook records that you have reviewed in your career.
Yes, yes.
You had no reason to doubt that they came from Facebook or they were authentic.
Yeah, I don't deal with the authenticity part, but yeah, they look like other Facebook records I have seen in other cases.
The Facebook records that you reviewed of Michael Shaver's account had personal information about Michael Shaver, pictures of him, the kids, things like that, or is that beyond your scope?
I was not focusing on that content, so yes, there may have been some, but if you asked me what, I could not tell you.
Facebook provided IP addresses for activity associated with Michael Shaver's account, right?
Correct.
As well
Correct.
You have reviewed those IP address histories, correct?
Yes.
And you've actually reviewed them with Mr. Camuccio before on certain instances, right?
Yes.
Okay. The jury's been inundated with Facebook IP address information, so I'm just going to ask you a couple very simple pointed questions. Would you agree that over the 2-year period of records, there were multiple times where Laurie Shaver's Facebook IP addresses were the same as Michael Shaver's IP addresses?
Yes. I don't remember that within a short period of time, yes. I don't know. Was it?
Within minutes of each other.
I think that's correct.
And those instances happened throughout that 2-year period of time of records, right?
There were multiple such instances.
That would indicate, if they're both sharing the same IP addresses, that the device or devices used to log into those two accounts were located in the same proximity to each other.
They would have been connected to the same router, I would think, yes.
So it was a house router, they would likely both be in the house.
Yes.
Now, conceivably, the same person could have logged into both accounts if that person knew the password or had a device that was already logged in and done the postings on both accounts.
That's possible.
So my wife and I are in my house sharing our same router, sharing the same IP address. She takes my phone and posts. That would share the same IP address as mine.
Yes.
There were instances in Michael Shaver and Laurie Shaver's Facebook records that showed them sharing the same IP addresses up until even November of 2017 towards the end of the records.
I don't recall the dates, to be honest.
You know that there were multiple times, though.
Yes.
It wasn't an uncommon thing.
There were multiple times.
Fair enough. Thank you, sir. I appreciate it.
All right, Mr. Wiggs?
Yes, question or two. Counselor was asking you questions, hypothetical questions, about access to accounts, two accounts, at or about the same time. Is it plausible somebody could be at a Starbucks, for instance, accessing both accounts?
Yes, again, connected to the same modem. So whether it's a house, Starbucks, a mall, it's just the same router wherever that router is.
Thank you, sir.
Anything from the state? May the witness be released from his subpoena.
Yes, Judge.
Okay. Thank you for appearing today. You're released from further testimony, and have a good day. Your next witness?
Kelly Johnson.
Okay. Kelly Johnson. I told Miss Johnson to be here too. Judge, if he's not here, Do you want to take a moment to contact Miss Johnson?
yes.
Okay.
Can I step outside?
Yes, sir. Please step outside. break, so we'll wait for Ms. Johnson to arrive.
I just stand up there so I flag her in. Good.
Yes, sir, that's fine. All right, good afternoon, Ms. Johnson. Please come up to the witness stand. Please make yourself comfortable. Let me know when you're ready to go.
Right.
Okay, please state and spell your full legal name.
Kelly Johnson, KELLYJOHNSON.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Please support.
Yes, sir.
Ms. Johnson, would you say your name for the record?
Kelly Johnson.
And what do you do for a living?
I'm an attorney.
How long have you been an attorney?
I've been a member of the Florida Bar since 2013.
Tell us about your practice, what you do.
I practice criminal defense and family law.
You have other attorneys that work within your office with you
Yes, I have associate attorneys
here in Tavares?
in Tavares on Main Street.
You received an order in this case to represent Isabel Shaver.
I was appointed as an attorney ad litem.
Would you tell the jury why you were appointed in this matter?
Well, it was my understanding that the child in this case wanted to come forth and give some testimony under oath, and there was a motion filed. I was approached and asked if I would accept an appointment of as a guardian, as an attorney ad litem in this case, and I said that I would.
How long ago was that? Do you recall?
I believe it was March of 2022.
22, a few years ago.
Yes.
Now, when you were appointed, did you, without revealing any conversations between you and your client, did you discuss the matter, her knowledge, and what had happened with her?
When I was appointed, that formed the attorney-client relationship between the child and myself. And I began meeting with the child and discussing the relevant facts of this case and assisting her and guiding her with advice with regard to what her position was.
And during the time that you were representing her, at any time was her deposition taken?
She did have her deposition taken, yes.
Did you attend that deposition with her?
Yes, I did.
At any time when you were representing her, did I meet with you and your client?
Yes, you did.
Did I meet only in your presence?
As far as I know, you met with a child in my office in my presence.
I think twice, correct? the child, did she in any manner express, well, let me back up and strike that question. Did you advise Ms. Shaver, Isabel, correct?
Yes.
Did you advise her if she desired to proceed forward and testify in this cause that she would be waiving certain constitutional rights?
I advised her regarding the applicable law and possible ramifications in taking the position that she was in this litigation.
Was she advised she had a right to remain silent in this matter?
Obviously, I advised her of all of her rights.
Okay, including her constitutional rights, correct?
Correct. This is not litigation in which she is named as a defendant.
Did you meet with the state at all?
Yes, I did.
They were aware you were representing her?
Yes.
Did the state ever contact you to discuss anything with Isabel?
The state and I did have informal conversations about my representation of the child.
You didn't do any kind of psychological analysis, but did you feel that the child was being honest and straightforward with you?
I felt like the child was able to understand the conversations in which we had.
Did she appear to understand her obligation to testify truthfully in a court?
She appeared to understand that, yes.
All right, that's all I have. Thank you.
Thank you. State?
Ms. Johnson, before you became involved in this case, you were actually approached by Mr. Wiggs and asked to do this.
He did contact me, as I said, and asked if I would accept the appointment as an attorney ad litem.
And then, once appointed, and you were representing Ms. Shaver, there were multiple times that I saw you in the courthouse and would tell you, anytime your client wants to talk to us, just bring her on in.
Yes.
Now, if she were to do that, would she have any sort of legal protections to just come and talk without any sort of subpoena?
No.
So, in order to protect her rights, the only time the state actually ever talked to her was after issuing a subpoena and doing a formal deposition.
Correct.
But prior to that, from the moment you were appointed, the state said anytime that she wants to talk, we're here.
Correct.
Nothing else, Judge.
All right, Mr. Wiggs?
Yes, just briefly. Did law enforcement approach you?
No, I've never spoken to anyone from law enforcement.
Mr. Camuccio make any private calls to you?
I don't know what you mean by that.
Did he call you on the phone? Say he wanted to talk to her?
I don't recall.
Very well. I don't have any other questions on that matter.
All right, anything further, Mr. Camuccio?
Ms. Johnson, once someone has an attorney, like Ms. Shaver, is it fair to say it would be unethical for me to approach someone and talk to them when I knew they had an attorney?
Yes.
And as far as law enforcement, just going to talk with you once I knew that you were represented, if that was going to be directed, I would have to go through you.
Correct.
And once again, there would be no protections for your client if they just came talking. Is that fair?
That's fair to say.
And once again, it all came down to the time that she was made available was when she was given the subpoena and then given the protections based on that.
That's correct.
Nothing further.
All right, Mr. Wiggs?
You can step down and may we approach, please?
Yes, sir. And may Ms. Johnson be excused from her subpoena. Thank you for appearing today. You're excused from further testimony. Have a good day. All right, ladies and gentlemen of the jury, at this time, we're going to take a 10-minute comfort break. So, Deputy, please take the charge. Thank you. State's position on it?
I'm aware of nothing. I'm aware of, since she's not a child victim, I know nothing that would preclude the media's presence.
Yeah, that's the only issue I know is about child victims. I don't know generally about the outside of that.
All right, I believe the media may have agreed to point the camera away from the child witness and record the testimony only via audio. Well, the media's here. Is that what you intend to do, sir? Yes, Your Honor. Oh, and could you just state your name for the record? All right, sir. You intend to point the camera away from the child witness. Is that correct? Correct. All right. Then please proceed in that manner. Is that acceptable to everyone?
Yes, sir.
Okay. Mr. Wiggs?
That's fine.
All right. Thank you. All right, we're in recess.